So is that the first case, Way?
Yes, Your Honor.
Okay. So on the record in docket 20-03104, that's City of Lansing versus Lauren Way. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Deputy City Attorney Lisa Hagan Lawrence appearing on behalf of the City of Lansing.
Good morning, Your Honor. Gidget James appearing on behalf of Lauren Way, who is at defense table and standing to my right.
And ma'am, you are Lauren Way?
Yes, Your Honor.
All right. This is the time set for a plea today, I believe. Ms. Hagan Lawrence, how are we proceeding?
Thank you, Your Honor. Yes, after some discussion, Ms. James and I have agreed to a plea, and I believe her client intends to accept. The offer is that Ms. Way will plead guilty to the hinder, oppose, resist, obstruct charge with a killabrew to a deferred sentencing agreement under MCL 771.1, wherein you will determine a term of probation for not more than 1 year. And if Ms. Way complies with whatever terms of probation and pays all of her fees, I will dismiss that charge on the sentencing date. And then as far as the obstructing public way charge, in exchange for the guilty plea today, I will dismiss that charge.
Okay, so it's dismissed on whatever date I set under a year.
So long as all the terms are fulfilled
of
and the
probation.
fees are paid. If they're not, then a sentence would go, or then the conviction would go into effect at that time.
All right, so do you want this referred to probation then?
I think that may be best, Your Honor.
Okay.
And then if you want to set it for a date so that probation can get you that pre-sentence and you can determine what the best timeline is, I'm happy to.
All right. And Ms. James, that's your understanding of the plea agreement?
It is. That is a complete and accurate statement, Your Honor.
All right. And I see you've signed an advice of rights concerning your trial rights in this matter, Ms. James. Is that correct, your client?
Yes, you did.
All right. So I'll just go over the three main rights with your clients. Let me make sure I have the. So it's a plea to count two. Count one is to be dismissed.
Correct, Your Honor.
All right. All right, Ms. James, may I inquire of your client of their advice of rights concerning this misdemeanor plea?
Yes, please, Your Honor.
All right. So, ma'am, you understand that the maximum penalty that you may be facing, I know there's a sentence agreement or the plea agreement, and we'll talk about that, would be 90 days and or $500. Do you understand that, ma'am?
Yes.
Okay. And you've signed an advice of rights concerning your plea today. So this advice of rights indicates that you knowingly and you understandingly, voluntarily, and accurately waive your trial rights in this matter. Do you understand that?
Yes, Your Honor.
All right. Now there are three rights that I will go through just so you know. You know you have the right to trial by jury in this case. You know you have the right to counsel, and you're of course represented by Ms. James. She would cross-examine and contest any charges brought against you at trial. You understand that?
Yes, Your
And you understand you have the right to remain silent. Anything you say could not be used against you in trial. Do you understand that?
Yes, Your Honor.
All right. With that understanding, I don't have to do this. I learned, but I'm going to do it anyway. I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth
Yes.
under penalty of perjury?
Yes, Your Honor.
All right. I'm going to bring your attention back to the date of offense being, and I'm not. July 25th, 2020.
Yes.
All right. So I'll bring your attention back to July 25th, 2020 at the offense location in the city of Lansing. Why don't you tell me what you did to hinder, oppose, obstruct, or resist a Lansing police officer in the performance of their duties?
I did not stop when the officer told
Me too.
Okay, and you recognize that that officer was in uniform at the time? You recognized him as an officer?
Yes.
Okay, and you understand that he made a lawful command and you did oppose that lawful command?
Yes.
And that was all on East Michigan Avenue at North Ham's homes in the city of Lansing?
Yes, sir.
All right. Anything towards a factual basis, Ms. Lawrence, Hagan Lawrence?
No, Your Honor, thank you.
Anything, Ms. James?
No, Your Honor, thank you.
All right. I find that the guilty plea to be knowing, voluntarily, and accurately made. I'm going to refer to probation, so I'll refer to probation. And you'll walk her down to the 5th floor today?
Yes.
Thank you. Refer to probation for this matter. What they're going to do, Ms. Way, is they're going to ask you a bunch of questions, and then they'll put it in a report, and I'll take a look at the report, and on date of sentencing, we'll decide what options we have for you. Okay, ma'am?
Yes, sir.
All right.
Thank you.
Refer to probation, date of sentencing,
April 3rd at 30.
the April 3rd at 1:30. It's a little bit further in the future. We've had some cutbacks in probation, so we're sending it out just in case, okay?
Your Honor.
Yes.
This will be the day that I sign for probation, correct?
Yep, that's the day you'll come here to get sent.
Yeah, you'll come here on that day, and on that day, we'll decide what the term is and things of that nature. And we'll have a report for probation to give us some idea of how to approach this, all right?
Thank you for explaining.
All right, any question, Ms. Hagan Lawrence?
Just to clarify, so after the sentencing date on April 3rd, there'd be a deferred sentencing
Correct.
date? Okay,
Yeah, that's, the plan is just to get their idea on this,
perfect.
set up probation, and then set out a date for the deferred sentence.
The city has no further questions. Thank you.
All right, Ms. James, anything?
None, thank you. Your
All
Honor.
right, thank you. That's all for the record of this file.
Thank you.
We'll see you on April 3rd.
Thank you.
So we're on the record docket 22-03567, City of Lansing versus Frank Rapp. The city attorney is identified for the record. Mr. Gotti, this is your case.
Good morning, Ari.
All right. And you're here for Mr. Rapp?
I am, Your Honor. Today will be
All right.
dismissed, I understand.
Yeah, the city just made that motion. City moves to dismiss. The defendant is not here. Is that my understanding?
Yes, Your Honor.
What's that?
Yes, right.
I believe he was unaware of the time change and the hearing that Mr. Gani had, but the city doesn't have any issue with that.
Nor do I, Your Honor. Thank you.
I received information that Mr. Rapp is here.
Yes,
Do you want to check the hallway just to see Miss Williams?
no problem.
If he is here, he should be here and in here. Mr. Gani, we're just checking to see, your client may have checked in earlier today, and we're just checking to see if he's in the hallway or not.
Thank you so much. I'm surprised I told him that, well, thank you, Your Honor. I appreciate it.
Okay. All right. Well, if he was here, he's not here now, so we'll just go ahead and put it on the record.
Thank you.
It's my understanding the city moves to dismiss charges without prejudice.
Yes, Your Honor.
Is that a ticket or a complaint? It's a ticket. All right. All right. Anything else for the record in docket 22035667 from the city?
No, Your Honor.
Anything, Mr. Gani?
No, thank you. Have a great day, Your Honor.
All right. You too. Thank you. That's all for the record in 22035667. We're on the record in docket 22030046. That is Hamilton Road versus Earl Goss and Lexiana McDougal. At least in regards to in my docket, will the parties please introduce themselves for the record?
Gene Turnwald on behalf of the plaintiff, Hamilton Road Limited.
All right. And just for my purposes, I don't see an Earl Goss or a Lexiana McDougal as a part of the Zoom courtroom, and I don't see anybody of that name in the physical courtroom, but Mr. Turnwald, you can enlighten me on what's going on.
No knowledge of this hearing.
Okay.
This is just a simple landlord tenant action. The tenants, which is their habit, never appeared. I got a judgment. I then asked for a writ. They've been my tenants for approximately 5 years. Once they get the writ, they start making payments and we catch up, we're good.
Right.
Somehow this got set for motion on the writ. I've never heard that before.
I've never heard of that either.
So here we are.
I don't know why it was set for a motion on the writs. I do have the application order of eviction signed by yourself. It must be executed within 56 days, but I have to tell you, I've never seen the eviction set for hearing.
Well, maybe I could plead guilty. So we're
No,
not.
that's no. For the record, I'll sign the eviction, okay, and we can get you on your way. So I'll indicate for the record that I called the case. The eviction signed. It's your indication the defendants had no notice.
No, not of this particular hearing.
And notice of eviction hearing, I guess. Our step, we don't set this. This comes out of the civil department, right?
This came from Judge Ward, and we tried contacting both offices. My secretary did. She didn't have any luck, so here I am on a Monday morning.
All right. That, I guess, I don't know. This is not, we did have an original fail to appear concerning this. Yeah, there was a fail to appear at an earlier date at the pretrial. So I'll sign this January 23rd. And then we'll get you on your way.
Okay, thank you, Your Honor. Good to
Thank
see
you. It's good to see you. Take care, Mr. Turnwell. So we're on the record in 15-01478 GC FHC Capital Commons versus Erica Virola. Will the parties please introduce themselves for the record?
Judge, Judge, could you pass me for just one moment, please?
Sure. Are you representing FHC?
Yes, Your Honor. I'm just
All
on the
right.
record in another case. Thank you.
All right. So we'll place that one and we'll move on.
I also have the probably the next one for Michigan State University Federal Credit Union.
All right.
Thank you.
So let's go on the record in docket 19-03334 Midland Funding LLC versus Kim Johnson. Will the parties please introduce themselves for the record?
Good morning, Judge. Andrew Perry, P69402 on behalf of plaintiff.
And is there a Kim Johnson here?
Yes, I'm here, Judge.
All right. This is the time set for an objection to a order to set it. So it's order to motion to set aside order for installments payments. So this would be brought by you, Mr. Perry?
Judge, we filed the motion to set aside the payment order, and Ms. Johnson filed the objection to our request
right.
to set aside the payment order.
All right, Ms. Johnson, we'll hear from you on this matter.
I received paperwork from Mr. Perry stating we would remain with the $50 a month payment starting in February. And I signed those and I'm sending them back.
All right, so what is your objection then, ma'am?
They were going to garnish a part-time job I had, and I didn't want that to happen. So I agreed that I would remain on the $50 a month plan. I no longer
Mr. Perry,
have that part-time. I'm sorry.
Go ahead, ma'am.
I don't have that part-time job anymore. So I received the paperwork. I called the court and I told them I did not have that part-time job anymore and that I would pay that $50 a month starting in February.
All right, Mr. Perry, have you received anything along those lines? An indication of the $50 a week and they're no longer able to provide garnishment in this case?
So what happened, Judge, in this case was Ms. Johnson stopped paying this payment order back in October of 2020. So we filed our motion to set aside the payment order so we could start garnishing Ms. Johnson. And then I received her objection with an explanation as to what was going on. So I then sent her a new proposal saying, hey, start paying again in February. We didn't receive it back, so I didn't know if she was agreeing to it. But it sounds like, Judge, she signed it. She sent it back to me. So I think at this point I can withdraw my request to set aside the payment order.
All right, so I'll indicate for the record that you have a new order coming in regards to the collections process of $50 a week because she doesn't have the job to garnish wages anymore. And so that's the agreement that you'll propose?
I think it's 50 a month, Judge, but yes, we'll send in an amended payment order, a stipulated payment order. Yeah.
So let me indicate the parties all appeared. And the plaintiff will propose a new order for $50 a month. Is that correct?
Yes, Judge, starting next month.
Starting in February. And Ms. Johnson, that's your understanding, it'll be an order indicating $50 a month starting next February?
Correct.
All right. So the court will wait for the order to catch up with the file. Anything else on record on docket 1903334? Ms. Johnson?
No, sir.
All right, Mr. Perry, anything else on this file?
No, Judge, I think we're all set. Thank you for your time this morning.
All right, thank you. That's all for the record in 1903334. Thank you for your appearance. And Ms. Johnson, you're free to leave the Zoom courtroom when you're able.
Okay, thanks.
So, and we're on the record in docket 22-02363. That's LVNV Funding LLC versus Victoria Joseph. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Keith Sparks here on behalf of LVNV Funding.
All right. And is there a Victoria Joseph present? I see somebody in the waiting room. Let me admit them, and we'll see if that is Miss Joseph. Person on the cell phone, call-in user 517-898-8574. Would you please identify yourself for the record?
Ashley Frank.
Ashley Frank. Okay, ma'am, you're here for your 9 o'clock?
Yes.
All right. Mr. Sparks, I don't see Victoria Joseph in the Zoom courtroom, and I don't see her in the present courtroom. Is there a Victoria Joseph in the present courtroom? Mr. Sparks, how would you like to proceed? I've got this set for pretrial today.
We would request a default judgment under the 7-day rule, Your Honor.
All right, I have service was made by a process server in regards to Ms. Joseph. It was personal service concerning this date. Yeah, that's what I have for the file.
Yes, personal service answer was filed middle of December.
Okay. Yeah, personal service. There's an affidavit in the file. So the defendant failed to appear for pretrial. I will grant a default judgment.
Thank you, Your Honor.
For failed to appear. Anything else?
I don't have anything further.
Okay. So that's all for the record, docket 22-02363. Thank you for your appearance today, Mr. Sparks.
Thank you, Your Honor. Have a good day.
And we're on the record in docket 22-02495, TNT Financial versus Latasha Nicole Jared. Will the parties please introduce themselves for the record?
Good morning, Your Honor. James Meineke appearing on behalf of the plaintiff, TNT Financial.
Hello, I'm Latasha. Oh, sorry.
So you are Latasha Nicole Jared, ma'am?
I am.
All right. This is the time set for a pretrial in the matter, and I do have a pretrial statement form current with the file. Mr. Meineke, how did you want to proceed?
Your Honor, if we could have an opportunity to speak with Ms. Jared in a waiting room, we may be able to resolve this matter. I've read her answer, and I think I can answer some of her questions.
All right, Ms. Jared, would you be amenable to meeting with Mr. Meineke in a breakout room to see if you can resolve some of these issues before we go to trial, before we fill out the pretrial form, the pretrial statement?
Yes.
All right. I'm gonna have Miss Jared and Mr. Meineke placed in a breakout room. You should get a prompt and that prompt will take you to the breakout room if you hit it.
All right, thank you.
You're welcome. And then Miss Navijot, you let me know when you're able to go on your cases. I understand you're in another courtroom.
Thank you, Judge. It just probably another minute or so. Thank you.
Okay. Ms. Williams, do you have anything that needs to go?
I'm ready on everything, to be honest with you. I didn't receive any information or updates from the public defenders today, so.
All right. I saw Miss Robinson here and then I lost her, so we'll wait for her. I've got a few civil cases, as you know, that 2 or 3. But if she comes in, we'll work her in.
Sure. We can do that.
Are you getting used to the Miss Williams?
No, I still say Rishmawi sometimes. It's confusing. Well, it's better now, but sometimes.
A person who was just let in on the iPhone 2. Can you identify yourself?
Diamond Green?
Diamond Green?
Yes.
Okay, you're here for your 9 o'clock?
Yes, sir.
All right, stand by and we have a few cases in front of you.
Okay.
All right, Ma'am, are you represented by counsel today?
I believe so.
Okay. Mr. Calloway, you're here for your 9 o'clock? You're breaking up, Mr. Calloway.
I am. Can you hear me?
Okay, we can. Your public defender's right here, and I'm going, in a few minutes, I'll put you in a room with her, all right?
Thank you.
Okay.
I'm so sorry, Judge, for the wait.
Stand by, Miss Navajot. Is it Navajot?
Navjot, yes.
Navjot. All right. I just want to make
Thank
sure
you.
that. All right, and then we'll call your first. We'll call the first of your cases. All right, let's call the first of your cases, Miss Navjot. That's docket 1501478. That's 8 FHC Capital Commons versus Erica Virola. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Navjot Francis on behalf of Plaintiff's Attorney of Record P72322.
And ma'am, you are Erica Virola?
Yes, good morning, Your Honor. I'm Erica Varola.
All right. This is a time set for an objection to, this was an objection to installment payments. I believe this came from you, Ms. Virola?
Yes, sir.
All right. Have you had the opportunity to speak to Ms. Navjot about your objection?
No, not in person or on the phone or anything.
Ms. Navjot, would you be willing to speak with Ms. Virola in a breakout room concerning her objection to see if you can work anything out?
Judge, I believe this is her motion for installment payments, and it was plaintiff's objection to her motion.
right.
However, I do note that we misread her motion, and she was asking for $75 biweekly. I believe we read it as $75 per month, which is why we objected. But we would have no objection to the $75 biweekly. So
All right,
if that is still her offer, we would take back our objection, Your Honor.
All right, so Ms. Varola, I just want to make sure I have this, the order regarding installment payments. I have that the defendant must pay the judgment in installments as $75 every 2 weeks, starting February 1st. Does that sound like your original or the original order regarding installment payments?
I can actually start the installment payments with the next paycheck. I initially put February 1st, even though that, I mean, well, next month is February 1st.
Right.
The clerk recommended that I did it out like 6 to 8 weeks, and it was February 1st, so it's perfect actually, now that I'm looking
Okay.
at it.
So, and you don't, so if, so that, this is the one
I
that you
get
wrote
paid,
out?
actually, I'm sorry, Your Honor, not to cut you off. I'm just looking at my calendar. I get paid on the 6th. Or let me double check my calendar real quick to make sure I get you on my payday. One moment, I'm sorry.
You're all right.
Okay. Calendar. Okay, so I get paid on the 3rd. I get paid on the 3rd of February, Your Honor. So I could do
All
it
right.
on the start at the 3rd.
All right, so I think I have your order here that the defendant would, and it indicates the court entered a writ of garnishment for periodic payments August 9th of 2022. The defendant must pay the judgment in installments of $75 every 2 weeks. And you're indicating you could start it starting February 3rd, 2023. Is that correct, ma'am?
Yes, does that mean they're just gonna garnish out the $75 still, since we already had a garnishment going already?
Ms. Navjot, is the plan to take the $75 every 2 weeks out of the paycheck, or what is that plan?
She would have to make those payments directly unless she files a wage
Okay.
assignment through her employer. It would suspend the current writ of garnishment, and so she would have to make the
All right, so
arrangements to get those payments.
So this order would suspend the garnishment, and you'd have to send the $75 every 2 weeks. Is that your understanding, Ms. Navjot?
Yes.
Okay, and that's your understanding, Ms. Varola, that you would, so starting February 3rd, you'd pay $75 every 2 weeks.
Yes.
All right. I'm gonna go, Ms. Navjot, Ms. Varola, do I have your permission to amend the order indicating February 3rd, 2023?
I'm sorry, what,
You have February 1st, 2023. I'll amend it to February 3rd
Oh,
in order
yes,
to meet
yes.
with this agreement.
Yes, Your Honor.
All right, so I'm going to indicate February 3rd, 2023 per hearing with the permission.
Will I be getting the information of where to send the 75?
Ms. Navjot, does she have the information where to send the money?
It would be sent to the law firm. That's on all of the pleadings.
So do you have that
To the-
information as a part of your records?
No, I don't, Your Honor.
It's the 533 South Grand Avenue.
533 South Grand Avenue?
Oh, it's the
Lansing,
building,
Michigan.
it's the building that looks like the house by the CATA station?
I'm not sure.
Oh, okay. I think I know
But
exactly where it's at.
So it's 533 South Washington, Lansing, Michigan, and what's the zip code?
Sorry, 533 South Grand.
533 South Grand?
And the zip code is 48933.
48933.
And the phone number is 517-482-5600. 3800.
3800. All right, so I'll place on the record that the new order is signed without objection.
Okay.
And that the particulars for payment were placed on the record.
Thank you, Your Honor.
One more, just a question. Can I pay that in cash when I go up there? Do I need to bring a money order maybe?
If you can give the firm a call at that phone number, they can
Oh,
advise
okay.
you of the payment.
Okay, I will do that. Thank you.
Thank you.
All right. I've signed, so for the record, I've signed the order of new installment payments. Anything else for the record, docket 1501478? Ms. Navjot?
No, Your Honor, thank you.
Anything, Ms. Varola?
No, Your Honor, thank you.
All right, that's all for the record in that file. And then, sir, you can come up here, Mr. Kirby. Then I have your second file, Ms. Navjot. And that's docket 18-01583 GC, Michigan State University versus Bo Kirby. Will the parties please introduce themselves for the record?
Navjot Francis on behalf of Plaintiff's Attorney of Record P72322 on behalf of Plaintiff's Attorney of Record.
So it's actually Miss Francis, right?
Either is fine, Judge.
All right. So yeah, I've been calling you Miss Navjot. I'm calling you by your first name, Miss Francis. All right, thank you. And sir, you are Bo Kirby?
Yes, sir.
All right. This is the time set for an objection in the matter, and this was your objection. Is that correct, Mr. Kirby?
Yep.
And there was an objection to the installment payments, and your request is that the court look at $150 every month starting February 15th?
Yes, sir.
All right. And Ms. Navjot, you filed an objection to that order. So what is the purposes of your objection to the order that Mr. Kirby has requested?
Your Honor, based on the total amount of the judgments and defendant's income, we would request $300 per month.
Okay, I have the amount of judgment here is $9,000. Is that correct?
That is correct, Your Honor.
$9,363.59. Is that fair?
Yes, Your Honor.
All right. Concerning, I guess we can just put this all on the record rather than have you two meet. Is there any compromise in that you could pay more than $150 every month for the installment payments plan? You're about $150 apart.
Yeah, I mean, 300 is a lot better than I'm paying now, so I would be willing to.
You'd be willing to pay the $300?
Absolutely.
All right. So Miss Francis, did you hear that? If Mr. Kirby would be willing to pay $300 every month starting February 15th? Is that doable for you?
Yes.
Do you have any problem with me amending your order to read that?
I do not.
Ms. Francis, do you have any problem with that?
No, Your Honor.
All right, so I'll indicate that I'm amending the order. Order per Kirby. And I'll go ahead and initial everything, but that's $300 every month, starting February 15th.
It'll be the same day every month.
Yeah, it'll be February 15th every month at $300. Is that fair, Ms. Francis?
Correct, Your Honor.
All right. And so that's how the order will read as following. I'm just making sure that I've got your order correctly. Defendant filed a motion for installment payments with the court on December 4th, 2022. The court entered a writ of garnishment for periodic payments on August 9th, 2022. the court now has, and there's a stipulation, amend order per Kirby, that $300 every month, starting February 15th, and I've initialed anything that I've amended. Is that your understanding, Mr. Kirby?
Yes, sir.
All right, is that your understanding, Ms. Francis?
Yes, Your Honor.
All right, I'm gonna go ahead and sign that.
And Your Honor, just same as the prior case, Mr. Kirby is going to have to start making those payments. It will not come out of his garnishment.
All right, so it's the same as the prior case. That order will supersede any garnishment. So do those payments go directly to to that same address?
To the law firm, yes, Your Honor, to the 533
All right, and
South
are you
Branch.
familiar with that?
I am not.
All right, so let's go ahead and put that on the record, and make sure you've got something to write this down with.
Can I write it on my phone? Is that?
Yeah, that's fine, Jordan. Just as long as you got, I'll indicate for the record that the amended order is signed. So the parties appeared. Amended order is signed. And then the details for payment, Ms. Francis, and he'll go ahead and write it all down so that we don't have any ambiguity as to where he should make the payment.
It's the same phone number, 517-482-3800. And the address is 533 South Grand Avenue.
All right, that's Lansing,
Michigan.
48913.
Yes,
48933.
yes, Your Honor, that's correct.
All right, and that the law firm is the Heinz Law Firm?
Yes, it's Glasson, Reed, McLean, Campbell, and Shoemaker.
Okay. Any questions, Mr. Kirby?
No, sir.
All right. Any questions, Ms. Francis?
No, Your Honor.
All right, that's all for the record. Docket 1801583. I've signed the new amended order that I amended with Mr. Kirby's permission, and I've signed it. So
Thank
that's
you.
all for the record in 1801583. Thank you for your appearance, sir.
Thank you.
All right, thank you, Ms.
Thank
Francis.
you, Your Honor. Thank you.
And Mr. Meineke, did you have the opportunity to speak with Miss Jarrett in a breakout room?
Yes, Your Honor, we did. We need a brief period of time so we can exchange some information with Ms. Jarrett. So we'd ask for a little discovery in this matter and maybe set the matter for a final settlement conference.
What I've been told to by our civil department, which kind of makes sense, is to in order for avoiding the pretrial, writing out the pretrial. I'm gonna set this for a second pretrial.
Okay.
If I set it for a second pretrial, and then at that second pretrial, we can go ahead if things haven't resolved themselves to fill out the pretrial statement. Okay.
Okay, that's great. Thank you.
So,
Honor.
so parties all met in a breakout room. And a second pretrial has been set. How far do you think that we should set that second pretrial for, Mr. Meineke?
45 days, Judge? Would that work, Ms. Jarrett?
Yep, that'll
work.
Okay.
All right, so 6 weeks. March 6th at 8:30. So we'll set it for second pretrial for March 6th at 8:30. At that time, if this hasn't been resolved, we'll go ahead and fill out that pretrial statement on the record. All right, Mr. Meineke?
Yes, thank you, Judge. I appreciate it.
All right. Anything else on the record, Ms. Jarrett, in docket 2202-495?
No.
All right. We're all set, Mr. Meineke, on 2202-495?
Yes, you are, Your Honor. Thank you.
All right, thank you. That's all for the record in that file. Thank you for your appearance today. And Ms. Jared, you're free to leave the Zoom courtroom when you're able.
All right, thank you.
Ms. Sutter, how are you? When he rejoins us, let's see.
How much time does he need? I was gonna say like 2 or 3 weeks. Is that okay? Yeah, that's fine. Awesome. Yeah.
There he is. All right. So we're on the record in docket 210127. That is City of Lansing versus Maurice Callaway. Will the parties please introduce themselves for the record?
Good morning, Your Honor. I'm Annie Williams, Assistant City Attorney, appearing on behalf of the City of Lansing.
Aaron Robinson, Assistant Public Defender for Mr. Callaway, who appears over Zoom.
And sir, you are Maurice Callaway?
I am.
And you can hear me all right, Mr. Callaway?
I can.
You can or you cannot?
I can. Can you
All
hear
right,
me?
thank you.
You hear me?
I can.
Okay, thank you.
Okay. So this is the time set for a pretrial in the matter. Ms. Williams, how are we proceeding?
Your Honor, my understanding is that we will request an adjournment today for 3 weeks for compliance purposes.
Yes. So this is over a year old almost?
Yes, but we are about to resolve it, so that's the only adjournment that the city is going to ask for.
All right. Miss Robinson, is that your understanding to adjourn for one last compliance?
It is, Your
hearing
Honor.
In a year-old case?
Yes.
All right. Well, if this is looking to resolve it, I'm happy to adjourn it, but it's got to be the last time.
Yes, Your Honor.
So we'll adjourn 2 to 3 weeks, you said?
Yes, please.
All right.
Thank you.
All right. February 13th at 9 a.m. All right, Mr. Callaway, we'll see you again. This is adjourned for compliance. It is the last adjournment for compliance issue. It'll be the day before Valentine's Day, February 13th at 9 a.m. All right, sir?
Yes, sir.
All right. Please keep in contact with your attorney, Aaron Robinson, if you have any questions. Anything else for the record, Ms. Williams on docket 210127?
No, Your Honor.
Anything, Ms. Robinson?
No, thank you.
All right, thank you. That's all for the record, then.
Thank you.
And you're free to leave the Zoom courtroom. Thank you, Mr. Callaway.
Thank you. Have a good day.
Would the person on the phone call 517-898-8574 please introduce themselves for the record?
Ashley Franks.
All right, Miss Franks, that is Miss Franks. Miss Franks, would you, I'm gonna place you in a breakout room with your public defender, Miss Sutter, all right?
Okay.
All right, so I'll wait for you to join, Lauren, and then I'll.
Thank you.
I just admitted her in case you were wondering how she got. And then I'll let you place Miss Franks and Miss Sutter. Mr. Hall, are you there?
Yes, sir.
All right, Mr. Hall, do you have a lawyer today?
No.
All right. Mr. Hall, did you want to speak with the city attorney concerning your case, or did you just want to go on the record?
I guess that sounds fun. I mean, fun, interesting. Yes, I'll speak to the attorney.
All right, I'm gonna wait for the assistant city attorney to join the room, our room. All right, I'm gonna send you over to a breakout room and then I'll send the city attorney to join you, okay?
Thank you, sir.
You're welcome. And sir, on the Samsung cell phone, could you please identify yourself?
Yes, sir. Thomas Holmes.
All right, Mr. Thomas Holmes. All right. And you're here for your 9:30?
Yes, sir.
And that's Miss Sutter?
Miss Robinson.
All right. All right, I'm gonna have you talk to your public defender here in just a few minutes when she's out of meeting with another client. All right, sir?
Okay, thank you, Your Honor.
You're welcome. So, Mr. Holmes, when your public defender joins, I'm going to go ahead and put you in a breakout room with her, all right? Her name's Erin Robinson.
Okay.
And sir, you are Jaden Vimos Savitt?
Yes, Your Honor.
How do you say your last name, sir?
Vimosatit.
Vimosatit. All right. And it's my understanding your public defender is Lauren Sutter?
Yes, Your Honor.
All right. All right. Once Miss Sutter gets out of a breakout room and we put some cases on the record, you're in the right place. I'll probably place you in a breakout room with her, but you're in the right place, sir, okay?
Okay.
Sorry.
You're all right. Miss Sutter, you ready on Mr. Franks
Ms. Franks,
or Miss Franks?
just waiting on I think Mrs. Williams is trying to one quick question about that.
Okay.
I am ready on Grady Jones and.
All right, let's go on Grady Jones. Mr. Jones is here. So let me make sure I've got the right file. I have a 21 file
There's 3 open ones.
and a 20 file. All right.
There should be 3 open ones. Or they're not?
And there's a ticket in one of them. Yep.
Okay.
I didn't. This is the ticket. All right. So we're on the record in docket 20-03699, the accompanying ticket, and 21-00703. That's City of Lansing versus Mr. Grady Jones. Will the parties please introduce themselves for the record?
Good morning, Your Honor. I'm Manny Williams, Assistant City Attorney, appearing on behalf of the City of Lansing.
Karen Robinson, Assistant Public Defender for Mr. Grady Jones.
Yes, sir, you are?
Mr. Antonio Marvell, Grady Jones.
Okay, how do you see your first name, sir?
Antonio Marvell, it's not hyphenated, it's just one.
Okay, Antonio Marvell Grady Jones. Thank you, sir. Ms. Williams, this is the time set for a pretrial in the matter. How are we proceeding today?
Your Honor, the public defender explained that Mr. Jones is going to be in jail, so the city agreed to allow the defendant plea for a failure to display ops and a calibru for time served. In return, the city will dismiss the no insurance and the drove unlicensed.
All right, so is that your understanding, Ms. Robinson?
It is, Your Honor.
So there's an agreement to plead to the fail to display a valid license, which is a misdemeanor. So plea to this portion of ticket with a Killebrew agreement of time served.
Yes, Your Honor.
And that is a 90-day under the city code, 90-day, $200.
100. Yes.
Okay. 90 days, $100. Okay, and with a plea to the failed to display ops, the driving unlight, the file 21-00703 will be dismissed. For plea agreement. And the file 20-03699 is dismissed per plea agreement. Is that correct?
Yes, Your Honor.
Right, Ms. Robinson, that's your understanding of the plea agreement?
It is, Your Honor.
All right. Is there any objection to immediate sentencing in this matter?
No, Your Honor.
Any objection, Ms. Robinson?
Your Honor.
All right. May I inquire of your client of his advice of rights on his misdemeanor plea?
Yes.
All right. Sir, you understand that the maximum penalty you may receive if you plead guilty to failed display ops is a 90 days and or $100. Do you understand that, sir?
Yes, I do.
All right. And you understand that there's a negotiation that is this and no upfront jail in this matter. But if I don't follow that agreement, you can withdraw your plea. Do you understand that?
Yes, sir.
All right. If your plea is accepted to this misdemeanor, then you'll be giving up the filing trial rights, and I'll walk you through those. All right, sir?
Yes.
Okay, you have the right to a trial by jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have witnesses against you appear at trial. You have the right to counsel and to question those witnesses against you. You, of course, are represented by attorney, public defender Erin Robinson. She would cross-examine and contest any charges brought against you. Do you understand that, sir?
Yes, Your Honor.
Okay, you have the right to have the court order any witnesses brought in your defense to testify at trial. You have the right to remain silent at trial. You have the right not to have to use that silence used against you. And you have the right to testify at trial if you choose to testify. Do you understand your trial rights in this matter?
Yes, Your Honor.
It's my understanding you'll be pleading guilty and you'll be waiving your trial rights today. Is that your understanding?
Yes.
So if you plead guilty today, you'll be giving up the claim that this is due to any threats or promises other than the plea agreement. You understand that?
Yes, Your Honor.
All right. I'm going to bring so I'm going to have you raise your right hand. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right. I'm going to bring your attention back on the ticket. Let me find the ticket. So on or about December 18th, 2020, at the North King Boulevard near Oakland and Lansing, were you on that date at that time at that location?
Yes, Your Honor.
And did you fail to display a valid license to law enforcement at that time?
Yes, Your Honor.
All right. Any questions concerning the factual basis, Ms. Williams?
No, Your Honor.
Anything, Ms. Robinson?
No, Your Honor.
All right, I find the factual basis to be knowing, voluntarily, and accurately made. We'll go to immediate sentencing without objection, which is already indicated. I know that I've got to do a $75 crime victims' rights fee, a $50 state fee. Your fine for this case will be $75 for a grand total of $200. Do you need some time to pay that to the city of Lansing, sir? About how much time do you need? About a month? All right. So the $200 fine to be paid, we'll make it on March 1st, okay? All right, March 1st, 2023. Anything else for the record from the city of Lansing?
No, Your Honor.
Anything,
Thank
Ms.
you.
Robinson?
No, thank you, Judge.
All right, that's all for the record and in all three of these files. But this is the accompanying ticket and docket 20-3699 and 21-00703. Thank you for your appearance today, sir.
Thank you.
Who's next, Mrs. Williams?
The public defender wants to handle Palomino first.
Palomino?
Yes.
All right.
And I think there's 3 or 4 people and we're ready to go on after that.
All right. This is a ticket, right? This Palomino?
Yes.
All right. So we're on the record in ticket or case number 22 L27177741. That's City of Lansing versus Juan Antonio Palomino. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Emmanuel Williams, Assistant City Attorney, appearing on behalf of the City of Lansing.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter appearing on behalf of Mr. Palomino, who was standing to my right.
And sir, you are Juan Antonio Palomino?
Yes, sir.
All right. This is the time set for a pretrial in the matter. Ms. Williams, how are we proceeding?
Your Honor, my understanding is that Mr. Palomino needs 3 to 4 weeks to comply with the city request. So we are asking to adjourn for 3 to 4 weeks.
That's correct, Your Honor.
Okay, 3 to 4 week adjournment for compliance purposes. Okay, this was previously adjourned for 60 days on November 15th for compliance purposes. And we reset it, and then the defendant failed to appear. Mr. Palomino, it's a bad idea not to appear for court, all right? So if you have any questions, please keep in contact with Ms. Sutter. She'll let you know when you need to be here, all right? Because this will be the last adjournment of the case, all right? Whatever happens, this adjournment will be the last. I've got one failed to appear on the 27th. That's what you want to avoid, all right? So 3 to 4 week adjournment for clients for compliance purposes.
February 13th at 9.
February 13th at 9 a.m.
And Your Honor, if I might make a small request.
Sure.
Mr. Palomino does drive up from Chicago for these hearings. I understand there is a fare to appear. I think that might be because of the transportation issues. Would he have permission to appear via Zoom for that hearing?
Any objection to that?
No, Your Honor.
I have no objection to that. Mr. Palomino, if it gets you here and we get you by Zoom and we can take care of it, let's do it that way, all right? All right. So I will say that a Zoom appearance is acceptable.
Thank you.
Anything else for the record in docket 22 L27177741, Ms. Williams?
No, Your Honor.
Anything, Ms. Sutter?
No, Your Honor, thank you.
All right, that's all for the record in that file. We'll see you on February 13th, Mr. Palomino, okay? All right, thank you. Would be green?
Yes.
So we'll do the. All right, whoever's that's probably gonna get muted. Ms. Green, we'll call your case. So that's ticket 19L2532181, City of Lansing versus Diamond Green. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Amani Williams, Assistant City Attorney, appearing on behalf of the City of Lansing.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Green, who joins us via Zoom.
Ma'am, you are Diamond Green?
Yes, sir.
All right, and you can hear me all right, Ms. Green?
Are you able
You
to
can
hear
hear me
me?
all right, Ms. Green? Yes, I can hear you. Can you hear me?
Yes, sir.
All right, thank you. Ms. Williams, this is time set for a pretrial in the matter. How are we proceeding?
Your Honor, the city moves to dismiss at this time.
No objection.
All right. And this is a ticket?
Yes, Your Honor.
All right, Ms. Green, my understanding is the city is moving to dismiss without prejudice today. That means that if there's additional evidence, they may come forward. However, for our purposes today, the case is dismissed. All right, ma'am?
Yes, sir.
All right. Anything else for the record in docket 19L2532181, Ms. Williams?
No, Your Honor.
Anything, Ms. Sutter?
No, Your Honor, thank you.
All right, that's all for the record in this file. Ms.
Excuse
Green, you're
me.
free to leave the Zoom courtroom.
I have one question.
Sure.
I currently bonded out in a different city for you guys. Do I get that bond money back, or is it just I had to pay it and that's it?
I don't think it's for this matter.
No, she was given a cash bond in this.
Yeah, I don't think she has a cash. I think she's talking about a bond on another case.
No, she has like a $300 cash. $300.
I have a
That
bond
should
with
be
you
refunded.
guys.
Yeah, that should be refunded to her.
Yeah, I looked into
Hold
that
on.
last week.
Ms. Green, we're gonna pull you up on the computer and we're gonna see.
They're gonna take,
Okay.
she owes money on another case. So they're gonna take the money that she posted in her bond and they're gonna apply it to her open cases and anything that's left over that we.
All right. So Ms. Green, you have some open files with the city. And what they're gonna do is they're gonna apply some of that money to those open files. But
Okay.
they will refund the rest of the money to you, all right, ma'am?
Okay, thank you.
So you may want to get in touch with the City of Lansing Criminal Department in order to
Okay.
see what the refund is after it's applied to some of those costs, okay?
Okay, thank you.
All right. And you're free to leave the Zoom courtroom. That's all for the record in that file.
Okay, thank you. Have a nice day.
Is he here today?
Yes, he's on Zoom.
Okay. I'm looking for him on Zoom. I don't see him on Zoom.
There he is.
There he is. Okay. He was in a breakout room. All right. So we're on the record in docket 22-03041, City of Lansing versus Thomas Holmes. Will the parties please introduce themselves for the record?
Good morning, Your Honor. I'm Annie Williams, Assistant City Attorney, appearing on behalf of the City of Lansing.
Erin Robinson, Assistant Public Defender for Mr. Holmes.
And sir, you are Thomas Holmes?
Yes, sir.
And you can hear me all right, Mr. Holmes?
Yes, sir, I can.
All right, Ms. Williams, this is the time set for a pretrial in the matter. How are we proceeding today?
Your Honor, my understanding is that the public defender did not receive discovery on this matter, so we can adjourn for 30 days to allow Ms. Robinson to review the case file.
And Ms. Robinson, is that correct?
That is correct.
So it's a request for an adjournment for discovery purposes. I'll indicate for the record, it was originally set on December 19th. And then it looked like there was a rearrangement on December 19th. Anyway, Ms. Robinson, do you think do you think you have any of those discovery issues cleared up, or are you?
I just haven't received anything yet. I know
Okay.
our appearance wasn't filed until a little bit later, so
Okay.
that could be the case. I don't have anything.
All right. So we'll set it for a new pretrial date.
You want a final pretrial?
I think a new pretrial date's fine.
February 27th at 9.
February 27th at 9 a.m. This is a DWLS, right?
That's all right.
At 9 a.m. Anything else for the record in docket 22-03041, Ms. Williams?
No, Your Honor.
Anything, Ms. Robinson?
No, Your Honor, thank you.
All right, Mr. Holmes, we'll see you back here on February 27th at 9 a.m. All right, sir?
Okay, hey, excuse me, Your Honor.
Yes.
May I speak for a second?
Sure. Just don't talk about the facts of your case.
Oh, okay. I thought it was throughout though, this case.
I'm not aware of that. I have that it was arraigned on November 3rd. It was rearranged on December 14th. So it may have been some at some point in time. It looks like you arraigned on it twice. And
Yes.
oh, that was for a fail. That was because you failed to appear for the first arraignment. So you were arraigned on it initially. So at this point in time, February 27th on the driving while license suspended is the new date for compliance purposes.
Okay.
So that's all for the record docket 22-03041. I'll see you back here on February 27th.
Okay, thank you, sir.
You're welcome.
9 a.m., right?
9 a.m.
9 a.m. Okay, thank you. I think I pushed that great button and entered back into the court.
Let's see if I can find. That's a file and 2 tickets.
I have,
2 tickets. No ops, improper turn in a speed.
Speeding, yeah.
Okay. All right, we're on the record in docket 22 L2760331 0333 and file 22-03138. That is City of Lansing versus Eric Dante Hall. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Amani Williams, Assistant City Attorney, appearing on behalf of the City of Lansing.
And sir, you are Eric Hall?
Yes, sir.
Okay, and you can hear me all right, Mr. Hall?
Yes, sir.
All right. This is the time set for a pretrial in the matter. Mr. Williams, how are we proceeding?
Your Honor, I spoke with Mr. Hall this morning and we agreed that he needs about a month to resolve the outstanding issues on his license. So if the court would like to adjourn it for 30 days, they allow him that time.
Okay, so second pretrial for compliance purposes.
February 27th.
All right, so we're going to set this for second pretrial. In order for some of these issues to be resolved, we'll set it for February 27th at 9 a.m. on file 22-03138 and both of the accompanying tickets. So, Mr. Hall, do you have that? It's February 27th at 9 a.m.
Yes, sir.
All right. Anything else for the record? Docket 22-03138, Ms. Williams?
No, Your Honor, thank you.
Anything else, Mr. Hall?
No, sir. That's all.
All right, you should be all set. Thank you for your appearance today.
Thank you. Have a
That's
great
all
day.
for the record. 22-03138. Ms. Franks is by phone, right?
She was, I don't know if she's still in the breakout room from me.
I think she's on the phone.
She is on the
Yes,
phone
I'm right
call,
here.
yes.
All right. So we're on the record in docket 22-02902. That's the City of Lansing versus Ashley Franks. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Amani Williams, Assistant City Attorney, appearing on behalf of the City of Lansing.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Franks, who joins us via Zoom.
And ma'am, you are Ashley Franks?
Correct.
Okay, and you can hear me all right, Ms. Franks?
Yes, I can.
All right. This is the time set for a pretrial in the matter. Ms. Williams, how are we proceeding?
Your Honor, my understanding is that the defendant needs 6 more weeks to comply with the City of West, and I believe she also understands that this will be the last adjournment in the matter.
Is that your understanding, Ms. Sutter?
It is, Your Honor.
All right. For the record, we previously set this on for second pretrial for 60 days for compliance purposes on January 23rd, November 22nd, and set it for today. So, Ms. Franks, you understand this is the last adjournment in this case?
Yes, I do.
All right. We'll set it for,
February 13th at 9:30.
okay, set it for last pretrial for February 13th.
You know, that's about 3 weeks from now.
The case is at 7.
How much time do you think she needs? I mean, more than the,
Realistically, Your Honor, she's been asked to complete 20 hours of community service. She's a single mom, so I'm guessing that's gonna be a lot on the weekends.
right?
So I think realistically for her to do it and not have to call off of work, I think 4 to 6 weeks is probably more in line with what's realistic.
Well, and the community service is the point of resolution, right? She
Correct.
completes that and then,
Yes, Your Honor.
all right, so let's do 4 to 6 weeks out. Yeah, it does. So Ms. Franks, my assumption is you've been doing community service on this?
I have not started community service yet. I went my last
Right.
court thing. I ended up having COVID, so this is
All right, so you
Fine.
understand you've got the following time period until our next date to complete your community service? You understand that?
yes, I do understand.
All right,
February 27th at 9 a.m.
so February 27th at 9 a.m. Anything else for the record in docket 2202-902? Ms. Williams?
No, Your Honor.
Anything, Ms. Sutter?
No, Your Honor, thank you.
All right. Ms. Franks, you're all set. We'll see you back here on February 27th at 9 a.m. Okay, ma'am?
Okay, thank you very much.
Okay. So we're on the record in docket 20-03-103. That's City of Lansing versus Jeffrey S. Hanley Jr. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Manny Williams, Assistant City Attorney, appearing on behalf of the City of Lansing.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter, appearing on behalf of Mr. Hanley, who is standing to my right.
And sir, you are Jeffrey S. Hanley Jr.?
Yes, Your Honor.
All right.
Good morning.
Good morning. This is the time set for a pre-trial in the matter. Ms. Williams, how are we proceeding?
Your Honor, Mr. Handley is a co-defendant of Ms. Wei. She pled the deferred sentence this morning. And we would like to extend, the city would like to extend the same offer to Mr. Hadley. He will plead guilty to hinder, oppose, resist, obstruct, and the city will dismiss obstructing a public way. We will enter a calibrate a deferred sentence agreement under MCL 771.1, where Mr. Hadley will serve a term of probation not more than 1 year under the court discretion.
And is that your understanding, Ms. Sutter?
Not quite, Your Honor. My communications with Ms. Williams indicated the term of probation would be specifically 6 months.
That I did not miss, so Ms. Wei pled this morning.
Yes, I
Yeah,
did catch that.
and I did not give her a firm sentence. 6 months is fine to the court. Yeah, that's
Fine, Your Honor.
but I probably am sending him to probation anyway to have them kind of indicate what he needs to do on probation. And then we set it for that 6-month date. And then if it all goes well, it'll be dismissed at the deferred sentencing date.
Correct, Your Honor. And my understanding from listening to Ms. Wade's hearing this morning was the negotiation there was for the term of deferral, which by law is allowed to be up to a year.
Right.
Ms. Williams, in my conversations about Mr. Hanley specifically, she always referenced, or in her communications to me, 6 months was the term of probation requested.
That's
Okay.
fine. Your Honor, just to clarify, I only said not more than 1 year because I saw that you gave Ms. Wei a sentence in April. So I realized if I say that, the sentence might be even shorter than 6
Right.
months.
That's
And that was
true.
my intention to even have it shorter than 6 months.
Right. So I would say 6 months is because we're deferring these sentencings out to April.
Mhm.
So, but it could be less than 6 months. 6 months is a max.
So if we would word it as a maximum of 6 months, I think
That's fine with, I mean, 6 months is fine. I mean, it'd be unlikely that I'd set it out for a year, but I think.
That was my understanding, Your Honor. I
Yeah.
was aiming for less than 6 months.
Right, because we're scheduling sentencing so far out right now. So, all right, so its offer is plead to count two. Count two, dismiss count one. It's a deferred sentence under 771.1. The maximum penalty is 90 days and or $500. With the understanding that there's a Killebrew agreement of no upfront jail and a deferred sentence. So is that your understanding, Ms. Sutter? And then the deferred sentence, it would be we'd put a 6-month cap on the deferred sentence.
Yes, with that 6-month cap, yes, that is my understanding of the offer.
All right. May I inquire of your advice of rights of your client on his misdemeanor plea?
Yes, Your Honor.
All right. So, Mr. Hanley, my understanding is that you're going to plead guilty to count 2. There is the possible penalty of 90 days and or $500 in regards to that plea to count 2. Do you understand that, sir?
Yes.
Okay. Now, there's an agreement between the lawyers that this be placed on a deferred sentencing pursuant to 771.1. With that deferred sentencing, I would refer you to probation. Probation would indicate what your responsibilities are. And then we'd set this for sentencing, and then any further time you'd have to complete whatever probation has. And if you're able to do that, then we would, my understanding is that we would dismiss this case as a part of the deferred sentence. Is that your understanding?
Yes, Your Honor.
All right. So you understand in this misdemeanor count, you have the right to have a trial by jury, correct?
Yes.
All right. I'm going to walk you through all your trial rights in this. And then we'll go ahead and take a factual basis. All right. So as a part of your right to trial by jury, you have the following rights. You have the right to be presumed innocent. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have witnesses against you appear at trial. You have the right to counsel. You, of course, are represented by Lauren Sutter from the Public Defender's Office, and she would cross-examine and contest any charges brought against you. Do you understand that, sir?
Yes.
You have the right to have witnesses to be ordered by the court on your behalf. You have the right to remain silent during the trial. You have the right not to have that silence used against you, and you have the right to testify at trial if you choose to testify. Do you understand all your trial rights in this case?
Yes, sir.
So if your plea is accepted, you'll give up the claim that any of this plea was a result of threats or promises other than the Killebrew agreement, the sentencing. You're pleading guilty because you are in fact guilty. Is that right, sir?
Yes, sir.
And you're waiving all your preliminary right, all your trial rights today. Is that right? All right. I'm going to bring your attention to raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I swear.
All right. I'm going to bring your attention back. It's the July 25th date, right?
Correct.
Yeah, July 25th. Honor by July 25th. I missed it on that, but at East Michigan Avenue and Holmes Street in count 2. Can you tell me how you did hinder, oppose, obstruct, or resist a Lansing police officer in count 2? What did you do to make you guilty of count 2?
I was protesting and I remained silent and did not comply with a police officer.
Okay, and at the time you knew he was a police officer who's in uniform?
Yes, sir.
All right, and he indicated a lawful order and you opposed that order?
Yes, sir.
All right. Anything else for the record in anything concerning the factual basis, Ms. Williams?
No, Your Honor.
Anything, Ms. Sutter?
No, Your Honor.
All right. I find the factual basis to be understandingly, voluntarily, and accurately made on this case. And so I'm going to refer it to probation. They'll set up, they're going to ask you a bunch of questions. You just tell them, be candid with them, and they'll set up a report for me. And then we'll figure out what our options are in a few months. All right. It's going to take a few months to get there just because we're scheduling out. So the sentencing date in this matter is April 3rd at 1:30. And so
Sorry. This is my 6 months start.
yeah, it's the 6 months starts now, and then we'll make it a part of the probation so that so that if you go and answer them, because we're scheduling so far, April will cut into that, okay? And then we'll decide what's left on this, I know the nature of the killer group agreement and the deferred, that this allows me to have some options to tell you what to do, but we're looking at a 6-month cap regardless or less in this case for both you and Miss Way. So anything else for the record and docket, unless I get some surprise, okay, that's probably anything else for the record, docket 2003103, Miss Williams?
No, Your Honor,
Anything,
thank
Miss
you.
Sutter?
Your Honor, thank you.
All right, thank you. We'll see you on April 3rd, and you're gonna go report to probation today? All right, thank you, sir.
Thank you.
Bring in Mr. Jean, Your Honor.
Mr. Jean. Anthony Jean?
Yes.
Is he in the courtroom or is he
He's
on?
not, this is one of the cases where he's in custody out of county and the writ could not be completed, so we'll just need to get a reset date.
All right. So we're on the record in docket 22000871. That is City of Lansing versus Anthony Jean. Will the parties please introduce themselves for the record?
Good morning, Your Honor. I'm Annie Williams, Assistant City Attorney, appearing on behalf of the City of Lansing.
Aaron Robinson, Assistant Public Defender for Mr. Jean.
And this is the time set for a pretrial in the matter. There's been some off-the-record discussions concerning Mr. Jean's presence. Ms. Williams, how are we proceeding today?
Yes, Your Honor, just like Ms. Robinson indicated off the record that Mr. Jean's being transferred to prison today and would like to reset it for another pretrial.
Do we know which prison he's going to? So we just want to know where to writ him out.
I don't think he's going to prison. I think he's just has another court date today in another county, so today just wasn't gonna work.
Yeah, let's see if we can find exactly where to writ him out of. Okay.
Clinton County. Look it up.
What's that?
Clinton County.
Clinton County? Okay.
Did his homework already.
Okay, so February 13th at 9:30. And we'll do a writ out of Clinton County. Anything else for the record? Docket 22000871, Ms. Williams?
No, Your Honor, thank you.
Anything, Ms. Robinson?
No, Your Honor, thank you.
Okay, we're all set on that case. Identify some of these people on the Zoom. Sir, on the iPhone, would you please identify yourself?
Luis Ochoa, Your Honor.
Okay, you're here for your 10 o'clock, Mr. Ochoa?
Yeah, Your Honor.
And I have the Abood Law Firm is representing you?
Yeah, it's Mike.
Is that you, sir?
Anderson.
Yes. Okay. All right, so we'll call your case in just a second, sir, all right?
Okay. Thank you, Your Honor.
And then we had Mr. Bill. A person on the cell phone, 517-894-5190. Would you please identify yourself?
Yes, this is Frank Anthony Panetta.
Mr. Panetta, you're here for your 10 o'clock?
Yes, I am.
All right, and are you represented by counsel today?
No.
All right. Stand by and we'll call your case in a second.
Okay.
So we're on the record in docket 22-03465, City of Lansing versus Louis Ochoa Aguilar. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Manny Williams, Assistant City Attorney, appearing on behalf of the City of Lansing.
Good morning, Your Honor. Michael Anderson on behalf of the defendant, Mr. Ochoa Aguilar, who appears via Zoom.
And sir, you are Louis Ochoa Aguilar?
Yeah, Luis Enrique Ochoa Aguilar.
All right, and you can hear me all right, sir?
Yeah, yes, Your Honor.
All right, thank you. This is the time set for a pretrial in the matter. Ms. Williams, how are we proceeding?
Your Honor, would like to set it for a second pre-trial, 45 days out, to allow the defendant to comply with the city request.
All right, and that's your understanding, Mr. Anderson?
Yes, Your Honor, we received those requests today.
Okay, set for a second. 45 days out. Right. So, what date do we have? You can set this. Let's see, that's 6 weeks. So it does really matter. Yeah, that's all right. Just that. Okay, we'll set it for March 6th at 9 a.m.
Sorry, Your Honor, could you repeat that date, please?
March 6th at 9 a.m.
Thank you.
So, Mr. Ochoa Aguilar, we're going to set it for March 6th at 9 a.m. Please keep in contact with your attorney, Michael Anderson, and we'll set it for March 6th at 9 a.m. Do you have that date, sir?
Oh, yes, Your Honor.
All right. Anything else for the record, Ms. Williams, in docket 22-03465? Anything, Mr. Anderson?
No, Judge, thank you.
All right, thank you. That's all for the record in this file. Mr. Ochoa Aguilar, you're free to leave the Zoom courtroom.
Thank you, Your Honor.
Your Honor, I think we have the last 9 a.m. ready, Mr. Howard Martin.
All right, I forgot that we had another.
We have one more left.
I forgot.
One more left from the 9 a.m. He's been here very patiently waiting his turn.
All right, we're on the record in docket 22-03351. That is City of Lansing versus Howard E. Martin. Will the parties please introduce themselves for the record?
Thank you, Your Honor. I'm Manny Williams, Assistant City Attorney, appearing on behalf of the City of Lansing.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter appearing on behalf of Mr. Martin, who is standing to my right.
And sir, you are Howard E. Martin? Okay, and you can hear me all right, Mr. Martin? All right. Ms. Williams, this is the time set for a pretrial today. How are we proceeding?
Your Honor, my understanding is that we would like to set it for a second pre-trial 4 to 6 weeks out for compliance purposes.
And that's your understanding, Ms. Sutter?
It is, Your Honor. The city attorney hasn't yet made an offer. They would like him to do something first before reviewing that for an offer, so we would need some time for him to do that.
All right. So we can take that same thing. Okay.
February 27th at 9.
February 27th at 9 a.m. So we've set it for second pretrial on this OWI case for February 27th at 9 a.m. Any questions, Ms. Williams?
No, Your Honor.
Anything, Ms. Sutter?
No, Your Honor.
All right, Mr. Martin, we'll see you back here on February 27th at 9 a.m. All right, sir? Thank you.
That's fine.
Miss Nicholas and Nikki.
I would need a chance to.
All right, let's wait on that. Do you have anything else you want to put on the record right now?
I think I have caught up with all of my people ready to go. There's just a couple folks I need to talk to.
All right.
You can do Kelly Furden for me. What about Jaden I'm gonna murder the last name.
He's on Zoom. I need to talk to him.
All right, you just let us know who you need to talk to, okay?
Two folks here, person I talk to really quickly, then I'll hop on Zoom for that one. Thanks.
You're ready on Ferdin?
Yes. Isn't she a red?
Yeah, she was the one from Isabella.
So Nathaniel will have to go grab her, I
No,
think.
she went to MDOC.
Yeah, we just need to reset.
Oh,
We can't, not for a while. We gotta wait for her to go through the guidance center and get situated someplace.
but we can get a new date, can't we?
She's just gonna go to the thumb. She's a female.
Yeah, but the reading part is not as easy as you would think.
Okay.
And
Well, do you
I'm-
want to set it for like a review in 2 weeks and then we can see where she's at in 2 weeks and set it out?
Yeah, and I need to get with the criminal department. For a while, MDOC was refusing to transport on a ordinance case, so LPD had to go get her. So I need to find out if that's still the case or not.
Okay.
So we can set it for a review if you want.
Yeah, that's fine. We can just set it for review and then see where she's located.
Yeah, I don't. So let's set it for review and we'll set it way out.
Sounds good.
So we're on the record in docket 1801792 and 2200397. That's people of the state of Michigan versus Kelly Ray Ferdin. Will the parties please introduce themselves for the record?
Morning, Your Honor. Amani Williams, Assistant City Attorney, appearing on behalf of the City of Lansing.
Aaron Robinson, Assistant Public Defender for Ms. Ferdin.
Right, and this is my understanding, this is the time set for a pretrial in the matter, and it's my understanding that we have to writ the defendant out of the Michigan Department of Corrections, and there's going to be some time lag in regard to both of these files. So what we'll do is, to make sure that it doesn't fall through the cracks in some way, we'll set it for review hearing. And counsel, I guess I'll leave it to you how far out you want that review hearing in order to make sure that we don't lose track of both of these files.
I would just say 3 weeks. I mean, that ultimately, I don't think they're gonna lose track. She's got a felony case for which she's gonna be sentenced on March 21st.
All right.
So, you know, if we have to, we can run them all on that same day. But I would think 2 weeks would be enough to get her screened and have a placement ready so we know where to send the writ to.
All right. So let's at least we'll have a date to recheck the files.
Right.
February 13th at 9:30.
So February 13th at 9:30. Anything else for the record in docket 2200397 or 1801792?
No, Your Honor. Thank
All
you.
right. Anything, Ms. Robinson? All right, that's all for the record in these two files. So, Mr. Panetta, we can call your case to the record. You're there, sir?
Yes, I am, Your Honor.
All right. So we're on the record in docket 1803780. People of the state of, City of Lansing versus Frank Panetta. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Amani Williams, Assistant City Attorney, appearing on behalf of the City of Lansing.
And sir, you are Frank Anthony Panetta?
Yes, I am.
All right. Miss Williams, it's time set for a pretrial in the matter. How are we proceeding?
Your Honor, the city moves to dismiss at this time.
And this is a ticket, correct?
Yes, Your Honor.
All right, Mr. Panetta, the city moves to dismiss without prejudice, this case. That means that they could bring the case back in the future if they chose, if they had additional information. But for our purposes today, the case is dismissed. Do you understand that, sir?
Oh, okay. Yep.
So the case is dismissed. I have that you posted a surety bond in this matter. Is that correct, sir?
I did.
All
Yes,
right.
it is, sir.
All right. All right. So that would be between you and the bonding agent. But for our purposes, the city has moved to dismiss this case. Anything else for the record? 1803780, Ms. Williams.
No, Your Honor, thank you.
Mr. Panetta, do you have any questions of me?
No, Your Honor.
Okay.
That's great.
All right, you're all set, sir. You're all set, sir, and you're free to leave the Zoom courtroom.
Okay. Thank you, Your Honor. Have a nice day.
You're welcome.
Bye-bye.
Would the individual on the Galaxy cell phone please identify themselves?
Daniel Basinger?
Okay, Mr. Basinger, you're here for your 10:30?
Yes.
All right. We have a few cases to call in front of you, but you're in the right location. All right, sir?
Okay.
Why did you drop that on your Hershey baker? That was naughty. You wasted your fruit. Where?
On the iPhone, would you please identify yourself? You just joined the Zoom courtroom. And you'll have to take yourself off mute. And you just left.
So Brian, you can come on.
So it's
up
at
now.
10:30. So we're on the record in docket 2203-173, City of Lansing versus Raphael Bryant. Will the parties please introduce themselves for the record?
Thank you, Your Honor. I'm Manny Williams, Assistant City Attorney, appearing on behalf of the City of Lansing.
Aaron Robinson, Assistant Public Defender for Mr. Bryant, who's standing to my right.
And sir, you are Raphael Bryant? All right. This is the time set for a pretrial in the matter. Ms. Williams, how are we proceeding?
Your Honor, my understanding is that the city is going to be amending the charge with driving while license suspended to fail to display license, and the defendant will plead guilty to that.
To the no ops in possession?
Yes, it's under MCL 257.311.
811, it's
311.
311.
311. And it's 90 and or 100?
Yes.
Yes, Your Honor.
$90 days in the $100 fine. So that's an amended of the driving while license suspended ticket.
Yes, Your Honor.
To amended count 2 of no ops in possession. MCL 27257.311, 90 days or $100. Is that your understanding, Ms. Robinson?
It is.
All right. Sir, you understand you heard the lawyer speak. My understanding is you'll be pleading guilty to a second misdemeanor count. We'll be removing the driving while license, suspending and amending the ticket to read that you were no ops in possession on the date and time. That's under MCL 257.311. That's a 90 days and or $100. Do you understand that, sir? All right. And Ms. Sutter, Ms. Robinson, may I inquire of your client of his advice of rights on this matter? Okay. So you have trial rights in regard to this misdemeanor plea, and so I'm going to walk you through those so you know those rights that you're going to waive today to plead guilty. All right, sir? All right. If the plea is accepted, you'll not have a trial of any kind. So you'll be giving up the following rights. That's the right to trial by jury, right to be presumed innocent until proven guilty, to right to have the prosecutor prove beyond reasonable doubt that you are guilty, to have witnesses against you appear at trial. You have the right to counsel and to question any witnesses against you. You, of course, are represented by Aaron Robinson from the Public Defender's Office. She would cross-examine and contest any charges brought against you. You have the right to have the court order any witnesses that you may need for your defense. You have the right to remain silent. You have the right not to have that silence used against you. You have the right to testify at trial if you choose to testify. Do you understand all these trial rights you'll be giving up if you plead guilty today? And so you've heard that that this is an amended count to 2. If you plead guilty today, you'll be giving up the right to claim that this was due to any threats or duress. You're pleading guilty because you are guilty today. Is that right, sir? All right. I'm gonna have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? I'm gonna bring your attention back to October 29th of 2022 at the offense location of South Cedar in Glendale in the city of Lansing. On that date, were you on that South Cedar address in the city of Lansing on October 29th? All right. And were you driving a vehicle at the time? And when you were stopped by law enforcement, did you fail to have an operator's license in your possession?
The thing was, it was an ambulance coming in a car in front of me, smashed our brakes.
Okay.
And we couldn't. I didn't see the ambulance coming out the side.
Well, he's not asking about that. So he's just asking about, did you have a valid?
Oh, no.
Okay. At the time when the officer asked you, you didn't have a valid license. All right. I think that I meet the factual basis as understanding voluntarily and accurately made. Any questions, Ms. Williams?
No, Your Honor.
Anything, Ms. Robinson?
No, Your Honor. Thank you.
Ms. Williams, do you have anything to say in regards to immediate sentencing in this?
The city has no objections to immediate sentence.
Ms. Robinson?
No objections.
All right. This appears to me to be a case that, that immediate sentencing for the no ops in possession charge. So anything towards allocution, Ms. Robinson?
Your Honor, I would just ask that you sentence him to fines and costs for this matter. Mr. Bryant understands that he does have license issues that are out of state and is trying to work on them, but it is hard since he cannot drive.
All right, Ms. Williams? So I think the court will sentence you. I think this is no ops in possession is an immediate sentencing charge. So I have a crimes victims rights fee of $75, a state fee of $50. I will set the fines and costs at $75 for a full range of $200 in regards to fines and costs for this. Do you need some time to pay that, sir?
Sure.
Would a month suffice?
Sure.
All right. So we'll do payment. Today's January 23rd. We'll do payment to be made to the city of Lansing by March 20th. Oh, this is January 23rd. You're right.
Let's
So
just do March 1st. It's easy to remember and it's close to 30 days.
that's fine. March 1st is fine. By March 1st. So if you make payment, that $200 payment by March 1st, that'll keep you from getting show cause for non-payment purposes. All right, sir? All right, anything else for the record in docket 22-03-173? Ms. Williams?
No, Your Honor.
Anything else, Ms. Robinson?
No, Your Honor.
Okay, you should be all set. Thank you, sir.
No problem.
So we're on the record in docket 19-04538. That's City of Lansing versus Nicholas Danique. Will the parties please introduce themselves for the record?
Your Honor, Manny Williams, Assistant City Attorney, appearing on behalf of the City of Lansing.
Good morning, Your Honor. Assistant Public Defender Lawrence Sutter on behalf of Mr. Denight, who is standing to my right.
Sir, you are Nicholas Carl Danique?
Yes, sir.
Okay. This is the time set for a pretrial in the matter. Ms. Williams, how are we proceeding?
Your Honor, my understanding is that Mr. Denike is working on obtaining his license and he needs 30 more days, so I'd like to ask for an adjournment.
That's correct, Your Honor.
All right, so I think that's a valid reason for asking for a second pretrial for compliance purposes. And a new pretrial date is set for
February 27th at 9.
2/27 at 9 a.m.
And Your Honor, a small request. Mr. Denique is driving or having to find transportation from Auburn Hills. Would it be okay with the court if he were to appear via Zoom for that? period?
Zoom, is that acceptable?
No objections.
No, I have no objection to Zoom appearance.
Thank you.
So Zoom appearance is acceptable. Anything else for the record in docket 19-04538 from the people, from the city?
No, Your Honor. Thank
Anything
you.
from you, Ms. Sutter?
No, Your Honor, thank you.
All right, that's it, Mr. Denique. We'll see you here via Zoom is acceptable on February 27th.
Thank you so much.
All right, thank you. This is Ms. McGee.
Yes.
Okay. So we're on the record in docket 16L20712222. That's the City of Lansing versus Ashley McGee. Will the parties please introduce themselves for the record?
Good morning, Your Honor. I'm Manny Williams, Assistant City Attorney, appearing on behalf of the City of Lansing.
Good morning, Your Honor. Assistant Public Defender Lawrence Sutter on behalf of Ms. McGee, who is standing to my right.
And ma'am, you are Ashley McGee?
Yes, sir.
All right. This is the time set for a plea date set. Ms. Williams, how are we proceeding?
Your Honor, the city would like to amend the charge from the misdemeanor expired license to the civil infraction impeding traffic under MCL 257.676B.
676B, amend to civil infraction of, I have,
I believe it's $130. If that's what you're
yeah,
looking for.
of impeding traffic. Is there any points along with that?
No, it's 0 points, Your Honor.
0 points and $130 fine. Is that your understanding, Ms. Sutter?
It is, Your Honor, and I will be accepting responsibility for that civil infraction on Ms. McGee's behalf.
All right. So this is on, and I'll just indicate, so we're working from the same ticket on ticket L207122. We're going to amend it would be part 2 of that, which is the misdemeanor driving while license expired. And we'll be amending that to an impeding traffic under 257.676B. That's 0 points and $130 fine. Is that correct, Ms. Sutter?
Correct.
And on that ticket, you'll be accepting responsibility and you'll confirm responsibility on behalf of your client.
Yes, Your Honor.
All right. With that understanding, the acceptance of responsibility from defendant's attorney will order $130 as a fine. And does your client need some time to pay that?
About a month would be appropriate, or a month to 6 weeks.
All right. So we'll set that for March 1st.
Thank you.
So Miss McGee, you'll have till March 1st to pay the $130 fine, all right, ma'am? You can pay it up here on the 6th floor at the City of Lansing at the criminal department, all right?
Thank you so much.
Okay. Anything else for the record in docket 16L207122? Miss Williams,
No, Your Honor.
anything, Miss
Thank you.
Sutter?
No, Your Honor, thank you.
All right, thank you, ma'am. You're all set.
Thank you. I'm gonna send you some.
Trouble finding my cheat sheet. I find schedule.
I'm going to hop on Zoom so I can talk to Mr. Vimmelseki.
Okay.
Actually, I'm still in a breakout room on Zoom.
So you want us just to throw them in there?
If you wouldn't mind, I'm in
Or
room 1.
put them there, I should say?
Yes, please. Been hanging out there for a while.
Not as articulately said as I'd wanted to.
Oh, Your Honor, sometimes I have to take retents at English. You've heard me do it.
So we'll have Mr. Mr. Vilmoset, we're gonna have you placed in a breakout room with your public defender. Okay, sir?
Okay, thank you, Your Honor.
All right.
Thank you.
So we're on the record, docket 2203-487. That is City of Lansing versus Kenya Woodson. Will the parties please introduce themselves for the record?
Good morning, Your Honor. I'm Annie Williams, Assistant City Attorney appearing on behalf of the City of Lansing.
Aaron Robinson, Assistant Public Defender for Ms. Woodson.
And this was a set for pretrial today. The pretrial was set for 10 a.m. It is now 11:10. It has appeared that Ms. Woodson has failed to appear for pretrial. Ms. Williams, how would you like to proceed?
Your Honor, this is her first time as a failure to appear. The city would request a bench warrant bond forfeiture with a 48-hour hold.
Ms. Robinson?
We would just ask for the 48-hour hold as well.
So the court issues a bench warrant bond forfeiture with a 48-hour hold. Anything else for the record in docket 2203-487? Ms. Williams?
No, Your Honor. Thank
Anything,
you.
Ms. Robinson?
No, Your Honor, thank you.
All right, that's all for the record in that file. Ms. Sutter, who did you want to call?
If you don't mind, Your Honor, Mr. Vermolsathy.
You say that so well.
I took a guess and then he made sure whether I was right or wrong.
So we're on the record in docket 2203-547. That is City of Lansing versus Jaden Vamosity. Will the parties please introduce themselves for the record?
Thank you, Your Honor. I'm Annie Williams, Assistant City Attorney appearing on behalf of the City of Lansing.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter appearing on behalf of Mr. Vermolsathy. He is joining us via Zoom.
And sir, you are Jaden Vamosity?
Yes, Your Honor.
All right. And you can hear me all right, sir?
Yes.
All right. This is the time set for a pretrial in the matter. Ms. Williams, how are we proceeding?
Your Honor, the city requested a substance abuse assessment to be reviewed before extending an offer, and my understanding is that the defendant would need 6 weeks to complete that.
All right. This is so, and this is the first pretrial, right? This
Yes,
is set
Your
for
Honor.
first pretrial. So so the parties appeared. Is that your understanding, Ms. Sutter?
It is, Your Honor.
So the parties appeared at first pretrial. There's a request for an adjournment to seek compliance. And we'll reset for second pretrial
March 6th at 9.
for March 6th at 9 o'clock. So, sir, keep in contact with your attorney, Ms. Sutter. We've reset this for compliance purposes for March 6th at 9 a.m. All right, sir?
Okay, yes, Your Honor.
All right.
I got a question though. Would I have
Go
to
ahead,
put
as long.
would I have to put the same code in to join through Zoom?
Yes.
Yes.
Yeah.
It's the same Zoom number every time you appear in front of Judge Flores.
Yeah. So on
Okay,
that
thank-
March 6th date, you'd put in the exact same Zoom number.
You'll also be mailed a copy of all of that information.
Okay, thank you.
All right. Anything else for the record, docket 2203-547, Ms. Williams?
No, Your Honor, thank
Anything
you.
else, Ms. Sutter?
No, Your Honor, thank you.
All right, you're free to leave the Zoom courtroom. Thank you for your appearance today. We'll see you on March 6th at 9 a.m.
Okay, thank you, Your Honor.
And then, Your Honor, I believe we're ready to go on Mr. Beasley as well. Okay.
23-00026, City of Lansing versus Davion Beasley. Will the parties please introduce themselves for the record?
Your Honor, Assistant City Attorney Amani Williams, appearing on behalf of the City of Lansing.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Beasley, who is standing to my right.
And sir, you are Davion Beasley? All right. This is the time set for a pre-trial in the matter. Ms. Williams, how are we proceeding?
Your Honor, it seems like this is a deferred sentence day. I would like to explain my reasoning for the court before I go through with the agreement. My understanding is that Mr. Beasley is under 21 and that not having a criminal record would benefit his career, his future. That's why the city considered entering into a deferred sentence agreement. So the offer was to dismiss, hinder, oppose, resist, obstruct, and Mr. Beasley can plead guilty for furnishing false information. There will be the Killebrew agreement for the deferred sentence under MCL 771.1, where Mr. Beasley serves a term of probation with a maximum of 9 months.
So this is, so if I got this right, it's dismissed. There's a 2-count complaint, and he'll be pleading to which count?
He will be pleading to furnishing false information.
So count 2.
Yes.
Okay. So officer just so offers to plead to count 1, dismiss count 2, and then there will be a Killebrew agreement that he's to receive a deferred sentence under 771.1, and that is probation of, did you say 9 months?
Yes, Your Honor, maximum of 9 months.
9 months max, with the understanding that if he's be able to complete that probation,
the charge will be dismissed.
count 2 is to be dismissed.
Yes, Your Honor.
Ms. Sutter, is that your understanding of the plea agreement?
Just make sure, Your Honor, what Ms. Williams has stated is correct. You did say something I think might have been the wrong way around. I believe you said dismiss count 2 today if he pleads to count 1. It's the other way around.
Right,
It'll be dismissing count 1 of hinder and oppose. He's pleading guilty today to furnishing false information.
Right,
Count
so
2.
he's pleading guilty to count 2, and we move to dismiss count 1.
Today, yes.
Yeah.
And then at the end of probation, dismiss count 2 as well. That is correct.
And then after 9 months, would move to dismiss count 2 if he successfully completes his deferred sentence.
Yes, Your Honor.
All right. Is that your understanding, Ms. Sutter?
It is.
Mr. Beasley, is that your understanding? You've heard the lawyer speak. Is that correct? All right. So Ms. Sutter, may I inquire your client of their advice of rights?
Yes.
All right. So you understand as to count 2, it has a maximum penalty of 90 days in jail and or a $500 fine. You understand that? That would be the maximum penalty you could face if you're unable to complete your probation. You understand that? Okay. I'm gonna walk you through you have the right to trial in this matter. I'm gonna walk you through some of your trial rights you have in this misdemeanor case, okay? You have the right to have a jury trial. You have the right to be presumed innocent until be proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have witnesses against you appear at trial. You have the right to question those witnesses against you. You have the right to counsel. You're represented by Lauren Sutter for purposes of this plea. If we went to trial, she would be here to contest any charges and cross-examine any complaints brought against you. Do you understand that, sir? All right. You have the right to have the court order any witnesses to appear for your defense. You have the right to remain silent during the trial. You have the right not to have that silence used against you. And you have the right to testify at trial if you choose to testify. Do you understand these rights, sir? And is it your intent to waive these rights in order to plead guilty today? All right. If your plea is accepted, you'll give up the claim that the plea was a result of any promises or threats made to you other than the plea agreement You're pleading guilty because you are guilty. Is that right, sir? Okay. I'm going to bring your attention. So I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under the penalty of perjury? Okay, I'm going to bring your attention back to on or about January 4th, 2023 at the offense location of Maple Street in the city of Lansing. In count 2, tell me what you did in order to be guilty of count 2, which is the filing of false information to law enforcement.
Officer asked me for my name. I just gave him false information.
Okay, and you knew as an officer at the time you told him that? Is that a yes, sir?
Yes, sir.
Okay, thank you. Anything in regards to the factual basis from the city?
No, Your Honor.
Anything, Ms. Sutter?
No, Your Honor.
All right, I find the factual basis to be knowing, understandingly, and accurately made. I'm assuming the city wants us to refer to probation?
Yes, Your Honor.
Okay. So refer to probation. So you'll go down to the 5th floor to probation, answer all their questions, and they'll do a report for me. And in that report, we'll see what options are available to us when we sentence, probably in about 6 to 8 weeks, maybe 8 weeks, okay? 8 to 10 weeks. So I'll refer to probation and a new sentencing date.
April 3rd at 1:30.
April 3rd at 1:30. So make sure you appear in front of me on April 3rd at 1:30. We'll see what options are available. Right now, the best option right now is that if you're able to complete both of these, you won't have anything on your record, all right? It's kind of a big deal to start out that way, all right? So, all right, so we'll see you here on April 3rd, all right, sir? All right, thank you.
I'm having problem.
On the record in docket 22-01448, City of Lansing versus James Johnson. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Manuel Williams, Assistant City Attorney appearing on behalf of the City of Lansing.
Good morning, so Your Honor, Assistant Public Defender Lawrence on behalf of Mr. Johnson. I do not believe he is present.
All right. This was set for pretrial today. It was originally set for 10 o'clock. It is now 11:25. It appears that the defendant has failed to appear. Ms. Williams, how does the city want to proceed?
Your Honor, this is the second failure to appear for Mr. Johnson. Therefore, the city would request a bench warrant bond forfeiture.
Okay. Any comment, Ms. Sutter?
You know, I wasn't aware that this was a second. This is the first hearing I've had with him, so I was under the belief that this was his first failure to appear.
Yeah,
I have a failure to appear, Your Honor, under October 25th of 2022.
I also have the defendant failed to appear on October 25th, and a 48-hour hold was placed on that, and then it was reset for pretrial on January 23rd. So I will indicate that because of the non-appearance, the bench warrant and bond forfeiture is issued on the case.
Your Honor, I understand that it is within the court's discretion to order the immediate bench warrant. In knowing that this is his second failure to appear, this is a non-violent charge. I would ask if it's anywhere within the court's discretion to order the 48-hour hold still.
I don't have a problem with arguing the 48-hour hold. It appears that Mr. Johnson may have some home concerns, you know, and so I don't have a problem with placing a 48-hour hold in regards to Mr. Johnson. If we're able to get him here on that time, there's some question about that, but so I will place a 48-hour hold. He actually in his initial arraignment, he listed his address as homeless. So
yeah, he gave us the Holy Cross shelter.
So. All right, so that's all for the record, docket 22-01448.
Thank you.
How about Mr. K.O. Adams?
I have not seen him either, and there was no one in the hallway last I checked.
All right. I'm gonna admit everybody just so we have everybody. Let me. Do
That's why I was asking.
Sir, on the Motorola Moto 5G cell phone, can you identify yourself? Anybody on the Motorola Moto cell phone, can you identify yourself?
Not
Okay. No, they're not hooked audio.
Given the circumstances and that he failed to appear twice, I can give him the 32 Yes.
Let's go ahead and go on the record on the KO. So the Motorola is not audio, but that's a 1030 case. So we're on the record in docket 22-03162. That is the City of Lansing versus KONS Adams. Will the parties please introduce themselves for the record?
Morning, Your Honors. The City Attorney Manny Williams appearing on behalf of the City of Lansing.
Good morning, Your Honor. Assistant Public Defender Lawrence Sutter on behalf of Mr. Adams. I do not believe he is present.
Right. This is a pretrial initially scheduled for 10:30. It is now 11:28. It appears the defendants failed to appear. Ms. Williams, how would the city like to proceed?
Your Honor, this is my records show that this is the first failure to appear for Mr. Adams. Therefore, the city would like to request a bench warrant, bond forfeiture, and a 48-hour hold.
Ms. Sutter, any response?
We would just request the 48-hour hold. Thank you.
All right. The court issues a bench warrant bond forfeiture with a 48-hour hold. Anything else for the record, docket 22-03162? Ms. Williams,
No, Your Honor, thank you.
anything, Ms. Sutter?
No, Your Honor. Thank you.
Well,
I think we have
Basinger,
Basinger and Riggin. Oh, I have a question about the second one, Your Honor. Mr. Riggins was set for 11 o'clock. There, now it's listed as an OT, so an ordinance file. Ms. Williams has told me that is not the city's case. She says it's the state's, so I don't know what's going on.
Your Honor, we checked under JIS and it has the Mr. Dwayne as the prosecutor on that case.
And who, please?
On
Wayne
Riggins
Johnson.
23, oh, Johnson?
No, Jeremy Riggins.
Oh,
Jeremy
no,
Riggins.
the attorney, the prosecuting attorney on that file.
So
It
it's
could just be
JIS.
they entered the prosecutor wrong, so just a second, please.
23-00127.
This is definitely an ordinance case.
It's a trespass on a.
Sir, on the Motorola Moto cell phone, would you please identify yourself? You'll have to unmute yourself. What's your name, sir?
Jeffrey Mandeville.
Vendeville. All right, Mr. Vendeville, you're here for your 11:40, your 11:30?
Yes, sir.
All right, you're in the right place. I'm going to call some cases right before you, okay? So stand by.
Yes, sir.
So we're on the record in docket 2203315. That's City of Lansing versus Daniel Basinger. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Assistant City Attorney Emmanuel Williams appearing on behalf of the City of Lansing.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Basinger. I do not believe he is present.
All right, this was set for 10:30. It is now 11:33. It appears that the defendants failed to appear today. Basinger?
He's on Zoom. He's been on Zoom for like an hour and a half.
Oh, he is right there. You're right. Thank you.
Yeah, I'm right here.
All right. Have you had the opportunity to speak with Mr. Basinger?
I have not, Your Honor. I am still in Zoom.
All right, Mr. Basinger, I'm going to place you in a breakout room to speak with your public defender, Lauren Sutter. All right, sir?
Okay.
All right.
This is my fire.
Mr. Williams, are you in a conference room?
Yes, I'm at the court building.
Oh, you can come right in person if you choose to.
I don't have him represented by anyone.
Are you not represented today?
You talking to me, right, Taylor Williams?
Yeah, Kaylin Williams, you're not represented by counsel, are you?
No, I've had the city attorney.
Do you want to speak with the city attorney on your case?
Yes. Yes.
All right.
Oh, damn.
Do you want to speak in person or do you want to speak on Zoom with the city? She's leaving the courtroom to speak with you, so you can. I guess it's
okay.
up to
Yeah, I'm
you.
up on the 6th floor, so I mean, I can come down or they can come up, whatever.
Yeah, we're on the 6th floor too. So so Nathaniel will go get you, and then and we'll let you talk to the city attorney.
Okay, thank you.
You're welcome.
Yeah. All right. You want the short room? I'll leave. Yeah, yeah.
I think that your license is restricted. Are you working?
Yeah.
Get your license, so what's the situation with the
Okay,
license?
so the situation is, yeah,
Mr. Braddock, you can unmute yourself.
Okay.
All right. So I'm going to call your case docket 2202381. This is a
Okay.
show cause in regards to you, Mr. Braddock. You have an outstanding debt to the city of Lansing of $275.
Okay, I'm listening.
I can barely hear you with that noise in the background.
That's because I'm outside. It's like the only way I can. I'm walking home right now. So.
All right. Do you plan to can we make a payment plan in order for you to suffice that? All right. What amount of money per month would work for you?
For now, probably like $100 because of my living situation, and then my car just broke down. That's why I'm walking. So.
Okay. So how about this? I will set it. It's a $275 outstanding debt to the city of Lansing.
Okay.
And I will set it for $100 to be paid by February 15th.
Okay.
Additional $100 to be paid for March 15th. And then the final $75 to be paid by April 15th.
Okay.
Would that suffice, sir?
Yes, sir.
All right. If you make those payments on the 15th of February 15th, March 15th, and April 15th, we can avoid the show cause, and you can that'll keep you from being show caused. All right, sir.
Okay, I appreciate it.
All right. So if you make those payments to the city of Lansing Criminal Department by the 15th, that they have it in the computer, and you'll be all set. All right.
Okay. Thank you.
All right, you're all set. That's all for the record docket 2202381. You're free to leave the Zoom courtroom, sir.
If you don't take it.
Mr. Bassender, we can hear you in the courtroom.
Okay.
He's discussing his offer, so I want to stop. That's good. Put on the record, but still.
It got caught.
Mr. Vanderbilt has how much?
He didn't have his radio.
Oh no. Yeah, Amani's hanging out over there, so I got lucky.
Yeah.
I don't know that I love that she's hanging out where I am talking to defendants and meetings, but at least she let me in.
All right, let's do Mr. Vanderbilt. What's the
He just missed 419, but no collection cases, but you can refer to
I'm gonna refer to one. All right. All right, Mr. Vanderbilt, I'm going to call your case, which is docket 21L2685581 and 2L2700151. Sir, you are Jeffrey Vanderbilt?
Yes, sir.
All right. And I have an outstanding debt to the city of Lansing for $419. Are you aware of that, sir?
Yes, sir. I was in between jobs at the time. Right now, I'm just working. I do have a full-time job. It's just with landscaping, and there being no snow right now, I don't work. And I take care of my kids and family. So my wife is the one that does all the work, so to speak. And I intend to make payments.
What I'll do on this is I'm going to refer this to collections for that $419 debt. And so if you contact collections and let them know that they have the debt now, and then that'll get you off the show cause lift for the ticket. Because that's what I want to avoid is to show cause you again. And so let's just refer it to collections. It'll be a collections issue. And then you can make arrangements with them in regards to how you want to pay this debt. All right, sir?
Yes.
Oh,
that would be great.
All right. So I'm going to refer it to collections, kind of get you out of the show cause cycle, and then make sure collections is on the
6th.
Okay. So the collections is on the 6th floor, and you should report in person to set up some type of plan within 48 hours. All right. Did you hear me, Mr. Vanderbilt?
I'm gonna pay the ticket.
You still have to appear.
Mr. Vanderbilt, you kind of froze up on me there.
I can hear you.
Okay, so you should report to collections within 48 hours just to set up whatever plan, all right?
Sir, thank you.
All right, that's all for the record in dockets 21L2685581 and 21L2700151. Mr. Vanderbilt, you're free to leave the Zoom courtroom. Thank you for your appearance today.
Thank you.
Did you want to put Beasley Basinger on the record?
Yes, please.
All right. So we're on the record in dockets 22-03315. That is City of Lansing versus Daniel Basinger. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Assistant City Attorney Amani Williams, appearing on behalf of the City of Lansing.
Good morning, Your Honor. Good morning still. Assistant Public Defender Lauren Sutter on behalf of Mr. Basinger, who joins us via Zoom.
And sir, you're a Daniel Basinger?
Yes, sir.
All right. And you can hear me all right, Mr. Basinger?
Yes. It's
All right.
Basinger,
Miss
but it's Basinger.
Okay. All right.
It's all right. Everybody
Basinger.
says it wrong. Everybody says it wrong.
All right. Miss Williams, this is time set for pre-trial. How are we proceeding today?
Your Honor, the city requested the completion of 20 hours of community service, and if it's possible, like the request to set it out for 60 days to allow Mr. Basinger to complete the request.
Understanding the need for compliance, I can 60 days is a lot. So, but 40,
45,
yeah, we do
45.
40.
Okay.
Okay. So we'll do 40 days, Mr. Basinger, a 40-day an adjournment. And it'll be for 40 days. It's a new date.
February
2/27 at 9:30. So, Mr. Basinger, in order to comply with whatever the lawyers talked about, you should be back here on February 27th at 9:30. All right, sir?
Okay.
All right.
You'll get that in the mail as well, sir.
You'll get it in the mail as well.
Okay. So I got 40 days to do 20 hours.
Yeah, you got 40 days to do 20 hours.
Okay.
All right. Anything else for the record, docket 22-03315, Ms. Williams?
No, Your Honor,
Anything
thank
else,
you.
Ms. Sutter?
No, Your Honor, thank
All
you.
right, thank you. That's all for the record. Thank you,
All
Mr.
right.
Basinger. You're free to leave the Zoom courtroom.
All right. Thank you.
I can,
Sure, this is
okay, I can, if you can find, just shoot me an email, I'll send it to you, that's fine.
Okay.
We did
I'm
these.
pretty sure the email can be sent.
Yeah.
You sent it.
Even,
So-
even if that's really hard for me, I mean, any community service should be.
Yeah, if he can't get any of those, I'll see if there's another place to
Okay,
tell you about it.
sounds good, yep.
Thanks.
Alright.
We got a bunch.
That's
We
all
let's
for you,
let's
like,
finish up these 10:30s.
Have a good day.
Thanks, you too.
So I've not seen Mr. Dedine. Are you all set, Ms. Sutter?
That's everybody on my list.
All right. So let's start calling at 10:30. We'll just start going in order. Mr. Dedine.
I was going to dismiss it.
Okay, well, let's call it then.
Just one quick question, Your Honor. I know we talked about Riggins. Did we make a decision if there's a new date for that or?
Oh, I don't think we called that.
I can
We
call
talked
it.
about And then it occurred to me right now. I don't know if we
Yeah.
actually did anything with it.
Let's call Mr. Riggins while we have it, because. So we're on the record in docket 23-00127. That's City of Lansing versus Jeremy Riggins. Will the parties please introduce themselves for the record?
Thank you, Your Honor. I'm Manny Williams, Assistant City Attorney, appearing on behalf of the City of Lansing.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Riggins.
And this is a time set for a pre-trial in the matter. And there was some confusion as to whether this was a city case or
No.
a county case or a conflict case. Mr. Riggins has not appeared today. However, there's a notice, there's maybe some notice issues. Ms. Williams, how did you want to proceed today?
Your Honor, I'd like to set it out for 30 days to allow us time to clear out the confusion.
I think that seems appropriate, Your Honor.
Second pre-trial. All right, so
Yeah.
give me
I'll check
it.
with
So a 30-day date,
February 27th.
February 27th at 9:30.
I'm assuming your appearance. So I have to file.
Because it was,
Because you did.
yeah, it was the county, yeah, we
Oh,
checked it.
sure.
when-
You want me to turn it down?
We checked it on Wednesday and then.
I don't know
we
how to
checked
do
it on
that. I-
Friday.
I believe you
and
when you
it
say that.
was
I think there's an error there, but I do believe you.
Oh, just-
Yeah,
There,
it's a trespass
okay.
on a right, right, tell us it has to be
It
city.
has to be the city, but.
All right, so we reset that for February 27th at 9:30. Anything else for the record? Docket 23-00127. Ms.
Oh, Your
Williams?
Honor, thank you.
Ms. Sutter?
No, Your Honor, thank you.
All right.
All right, yeah, sure.
Have a good day, everyone.
Now we can call Mr. Dedine and the rest of these. And you've met with Mr. Williams, right?
Yes.
All right, we'll go ahead and call his case next. We're on the record in docket 22-03204, the city of Lansing versus John Dedine. Will the parties please introduce themselves for the record?
Thank you, Your Honor, Manny Williams, Assistant City Attorney on behalf of the city of Lansing.
All right, this is the time set for a pre-trial on Mr. Dedine's case. Ms. Williams, how would you like to? This was set for 10:30 and it is now 11:52. So it appears that the defendants failed to appear. How would you like to proceed?
Your Honor, I'd like to request a bench warrant bond forfeiture with a 48-hour hold.
Okay. With that understanding, the defendants failed to appear. I will issue a bench warrant and bond forfeiture with a 48-hour hold. Anything else for the record in 22-03204 and the accompanying tickets, Ms. Williams?
Your Honor,
All right, thank you. Let me write some of these and we'll. Mr. Dedine. And we'll take Mr. So we're on the record in docket 22-03327. That's the city of Lansing versus Kalen F. Williams. Will the parties please introduce themselves for the record?
Thank you, Your Honor, Manny Williams, Assistant City Attorney appearing
Mr.
on
Williams,
behalf
come
of
up
the
here.
city of Lansing.
All right. And sir, you are Kalen Williams? Sir. All right. This is the time set for a pre-trial in the matter. Ms. Williams, how are we proceeding?
Your Honor, we have come to a resolution on this matter. The city agreed to dismiss the civil infraction, equipment violation, and to amend the disobeyed traffic signal to impeding traffic. It's still a civil infraction, and the city will also amend the drove while license not valid or improper license to drove unregistered vehicle.
Okay, so, and the unregistered vehicle, is that a misdemeanor or a civil infraction?
It's a misdemeanor. It's under 257.215.
0.5. Unregistered vehicle. That's under 257.215. That is 90 days and or $100.
Yes, Your Honor.
With an amendment to that, that no ops the traffic signal is going to be amended to
Impeding traffic.
impeding traffic.
That's 257676B.
7,
And
6,
that's 0 points.
0 points. And is that $130?
I believe so.
I think it's a $130 fine. And then the equipment violation is to be dismissed.
Yes, Your Honor.
Do you have any objection to immediate sentencing?
No, Your Honor, I don't.
All right, Mr. Williams, you heard the nature of the plea agreement is to amend the no obstinate possession to driving an unregistered vehicle, to amending the traffic signal to an impeding traffic, and the equipment violation will be dismissed as a part of this agreement. Is that your understanding, sir?
Yes, Your Honor.
All right. The maximum possible penalty you can get on the misdemeanor charge is 90 days and or $100. I can tell you right now, I'm not going to send you to jail on this. Okay. So I tell you up front here. So you'd be, but that's the maximum possible penalty of what you're pleading to. Do you understand that?
Sure.
Okay. On this misdemeanor, since that's the maximum penalty, you have several trial rights in this, and I'm going to walk you through those. Okay.
Sure.
All right. You have the right to be tried by a jury. You have the right to be presumed innocent. You have the right to have a prosecutor prove beyond reasonable doubt that you are guilty. You have the right to have witnesses against you appear at trial. You have the right to question those witnesses. You also have the right to counsel. You understand that in this misdemeanor case?
Yes,
Okay. You have the right to have the court order any witnesses to appear in your defense. You have the right to remain silent during the trial. You have the right not to have that silence used against you. And you have the right to testify at trial if you choose to testify. Those are your trial rights, sir. Is it my understanding you're going to waive those trial rights and plead guilty to the misdemeanor driving an unregistered vehicle today?
Sure.
All right. If your plea is accepted, you'll be giving up the claim that any of this was due to any threats or duress. You're pleading guilty because you are guilty and because you understand the nature of the plea agreement. Is that true, sir? All right. I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Sure.
All right. I'm going to bring your attention back in the ticket. I'm going to find the ticket. On this misdemeanor amendment. So bringing you back to November 24th, 2022 at East Michigan on Grand Avenue. Were you on East Michigan on Grand Avenue on the date of November 24th, 2022?
Yes.
All right. And at that time, in violation of 257.215, were you driving an unregistered car?
Yes, sir.
All right. That's fine. You can also plead that you were not registered, that they didn't have a proper plate.
Yes.
Okay. All right. Any questions on the factual basis, Miss Williams?
No, Your Honor.
All right. In regards to the same ticket, sir, do you confirm in regards to that would be the amendment for the traffic signal? So amend count 1. Do you confirm that on that same time at that same date you were impeding traffic or you did disobey a traffic signal on that date?
Yes.
All right. So I find that is a confirmation of the ticket in count 1, which is amended to the impeding traffic, and then the final count of equipment violation is dismissed per this plea agreement.
Yes, Your Honor.
All right. And so in regards to immediate sentencing, there's a $75 crime victims rights fee that I can't waive. There is a $50 state fee for a total of $125. we'll add a $50 fine and cost. So that's $175. And then you've got $130 on the traffic, on the impeding traffic, and that's a 0-point offense. So that's a grand total of $215. I'm gonna make sure this is right, because I'll screw this up. I have a 305. Yeah. So we have a grand total of 305 for your purposes. Do you need some time to pay that, sir?
Yes.
All right. It's $300 to the city of Lansing for both of these tickets. And we'll put it out at, would 45 days be enough?
Yes.
All right. So we'll set it for, let's set it for March 1st. I don't know if that's what's going to
Hang
do.
on, find my special.
March 6th. March 9th. All right. So let's set it for March 9th for payment on both of these. So for the $175 March 9th and the $130 for the civil infraction March 9th, 2023. So if you make payment for those, for all those on March 9th, we can avoid any show cause or anything like that. Anything else for the record on docket 22-03327 and the accompanying tickets, Miss Williams?
No, Your Honor, thank you.
Do you have any questions of me, Mr. Williams? All right, you're all set. March 9th is the date for the payment, okay?
Okay.
All right. That's all for the record in that file. Thank you for your appearance, sir.
Thank you.
Who is me?
She is this whole time.
Miss Shirley, do you have a case in front of the court?
Well, yeah, I got sent court papers. I paid the ticket, but I still got the papers because I think my ticket was late. My payment was late.
Okay. So ma'am, we don't have you on the docket. You should be all set.
Oh, okay.
All right.
All right. So I just
So-
disregard that because yeah.
Yes, you can disregard it.
Okay. All right. Thank you.
Thank you.
Mhm.
So are the rest show causes? They are. You're good.
Yeah,
Yeah.
yeah, I think my docket is done. I have a probation violation hearing at 1:30. So
All right.
I'll be back for that.
You're all set. We'll see you then.
Yep, thank you.
And then let's just call these then. I'm getting cranky, and I'm more apt to issue bench warrants on these because they should at least show up, right? To fix their stuff. This is $270. At least show up, you know? So we're on the record docket 22L2748755B and 22L2748751. This was time set for a show cause for a failure to pay tickets for Feliciana Hernandez, $130 and $135. It appears that the defendants failed to appear, and a bench warrant and bond forfeiture. This was set for 11 o'clock, and it is now 12:05. And that's all for the record on those files. And we're on the record in docket 1807061. That's City of Lansing versus Fernando Montalvo. This is the time set for a show cause on an outstanding balance of $275. Time was set for 11 o'clock. It is now 12:07. The defendants failed to appear, and a bench warrant and bond forfeiture is issued. That's all for the record in docket 1807061.
Williams, Assistant City Attorney, appearing on behalf of the City of Lansing.
And sir, you are Canvas Terry?
Yes, Your Honor.
Okay, and this is the time set for a probation violation hearing. You're not represented by counsel today?
I've been trying to get in contact with the number she gave me and nobody never get in contact back with me.
Well, this is the time set for hearing. Ms. Williams, are you ready to proceed with the hearing today?
I am ready to proceed.
Okay, who would be your first witness today?
Well, I wasn't going to contest the findings of the probation officer, so it would be probation officer Hannah.
Okay, so let's get Brendan here. So we'll get Brendan here.
Okay.
We're gonna go forward with the hearing, sir. I mean, this is, I don't know how many times I can adjourn this for you to get counsel or for itself to work itself out. I will state from the record, we were on May 3rd, there was a probation arraignment and there was a violation. Made application to the public defender's office on July 18th. We set a formal hearing. You admitted to the violation on August 2nd. On December 6th, we did another hearing date. On December 20th, you were failed to appear. And then you indicated that you were going to seek to have at your last time. So on December 29th, we had you come in here again and you were arraigned on the probation violation by the magistrate. On January 17th, you were indicated you were going to make application again, and now it's January 23rd. So let's get Mr. Hannah up here and you can talk to him and we can figure out where we're going with this. All right?
Because I'm keep missing work and I'm on a 90-day probation at work. So.
Well, I mean, you're looking at you're looking at least that. Let's see. I have you pleading guilty to an operating while intoxicated on December 13th, which is what this is a probation violation from, right? So, and then you were on deferred sentence.
No, excuse me, Honor. I'm talking about, I said, yes, I do want to get it done because I'm keep missing work.
Right.
I'm on a 90-day probation at work.
Right. What I'm afraid of is if I violate your probation, I'll put you in jail. Then you're really going to miss work.
Yeah, I don't want to.
Okay. And that, I mean, that's, that if you want a way to miss work, that's a way to miss work when you can't get there.
Yeah.
So let's talk to Mr. Hannah and let's figure out what we're going to do here. All right.
Okay.
All right. So have a seat and we'll wait for Mr. Hannah to come up.
Sit back.
Yep. Okay. Yep. But we're ready to go with the hearing and we're calling Mr. Hannah up as a witness and we'll see if we can resolve this. Okay.
The thing was for me to do my class. I did my class, and I just
talk to your probation agent. Okay. Yeah, let's. If there's something new that we should look at, let's figure it out. Okay. How about Laverne Wakefield? Okay. All right. So, Mr. Wakefield, you can come up here. This is just an arraignment. All right. So. We're on the record in docket 21-02752. This is City of Lansing versus, actually, this is people of the state of Michigan, I think. The child abuse fourth?
Yes.
Yeah, so this is a people of the state of Michigan. It's an arraignment, so you don't, we're fine. What this arraignment's for is so I can tell you the natures of your probation.
I'm aware.
So you can deal with the allegations that have been brought against you. All right, sir. And by the way, you are Laverne Wakefield?
That's correct.
All right. The purpose of the arraignment is request and summons for probation violation. It was signed by Alexis Trott for Mario Ledesma on August 2nd. It was signed by Judge Simmons on August 3rd. It's alleged that you have violated your terms of probation by, in violation 6, failed to pay fines and costs, balance due of $111.
Excuse me, Judge. That's not the right current probation violation. You're looking for one from December 9th.
Oh, I got it. Okay. Sorry, that was one before.
Yeah, it's the same.
So this was by Heather Duhosky on December 9th, signed by Judge Buchanan on January 9th. And it's actually a little lighter, okay? The request and summons for probation violation. It's alleged that you violated terms of probation into failing to make any payments with a full balance of $665 owed and testing positive for marijuana on November 29th, 2022 at the Pats. Do you understand the nature of the allegations that have been brought against you?
Yes, I do.
All right. Now, in this matter, the court has to inform you, you have a right to a hearing, and to contest this hearing, you have the right to be, you right to have a lawyer, okay? You have the right, if you can't afford a lawyer, we will provide you with the public defender's office so that you can seek a lawyer in this proceeding. We'll do it within 14 days, so you have enough time to get a lawyer. At this arraignment, since this is child abuse fourth case, do you plan on seeking counsel in this case?
No, sir.
Okay. So I'm gonna set it out. Okay, we're gonna set it out for hearing. All right. Do you know who your current probation officer is?
It just got switched. I just reported last Thursday.
It's Jody.
However, this is a Judge Simmons case. This isn't even our case. I'm unsure how it's on our, not our case.
All right, so I'm gonna set it. I'll set it for hearing. I'll just arraign him on the probation violation and set it for hearing.
Let me see if I
So
can figure out how she does
yeah,
it.
let's see if we can. So go ahead. I'm gonna set it for hearing. It's not my case.
Actually, I judge.
It's signed by Judge Buchanan. Is it Judge Buchanan case?
No, Simmons.
Judge Simmons, you're on probation, Judge Simmons.
Is there any way just to plead guilty to the violation?
I'm afraid to, because I'd be certainly able to take your guilty plea to the violation, but then I'm afraid that then it'd get lost some way because you're not in violation of me, you're in violation to her.
Yeah, that's what the bailiff told me over there too. So
Right.
Gotta see.
Yeah, so I can arraign you today and make sure that you're arraigned and you understand all your rights in this case.
Yes, sir.
But then whether we can set it for hearing. She's in a jury trial right now.
Yeah.
But we may set it next to something else in the next, another probation violation hearing or arraignment. I don't know how it got. Maybe it got to me because she's in jury trial.
I think
No,
so.
it was scheduled.
Yeah, supposed
It was scheduled.
2 Mondays ago, I missed my court date.
Okay.
I'm sorry, Judge, I tried to find it. I forgot.
I see what happened. Did you plead guilty already to the violations of the probation? Or that was?
No, that was a different violation.
That was August 30th. That was the last one. Okay. And then you did have a fail to appear on January 9th.
Yeah, for court.
Yeah.
Yeah.
Okay,
I went down to the probation department and I talked to Heather for.
Okay.
You know what I mean? And she just
So
let's pushed it back to.
let's set it for hearing on her docket, just to be safe.
All right.
And there's no hurry.
Where has to be within 2 weeks?
It does have to be within 2 weeks.
February 6th at 1:30.
Okay.
I made a spot to make it rescheduled, but
You said that was February 6th?
Yeah, and you should get a notice. Are you able to print a notice for him? Okay. We're more wondering about the Zoom, but that's part of the jury trial that's going on.
Doesn't sound pleasant.
It's an animal cruelty case, but that doesn't sound like an animal cruelty case,
That's
does
probably
it?
the way my kids sound when they call the police last year.
Yep.
That's right.
So we'll set it for a probation violation hearing on February 6th, 2023 at 1:30. Yeah.
Can I do that? Do you have a Zoom?
I would show up in person just in case. All right, just in case. Just because I don't know what her rules are, but you can't err on the side of being in person. All right, so I'll indicate for the record that we arraigned you on the probation violation. And we set it for hearing in front of in front of Judge Simmons. On that February 6th date. And if that changes, just they have your address so they can make them available to them. All right. You're all set, Mr. Wakefield.
Thank you. Have a good rest of your day.
You too. I saw Mr. Hannah here.
Yes, I spoke with him. We got a result.
Okay. Well, that was fast. Okay. Mr. Terry, you can come up here. So we're on the record in docket 20-01503. That's the state of Michigan versus Canvas L. Terry. This is the time set for hearing. For the record, Mr. Hanner did show up in regards to the probation violation hearing. Ms. Williams, you've already indicated your appearance for the record.
Yes.
How do you want to proceed?
Your Honor, Mr. Terry spoke with me and Mr. Hanna, and he explained that he already took the AHSE class, and he's trying to register for the victim impact panel, and he said that he will be able to do that in the next 2 weeks. Can you hear me?
Okay, so I'll repeat because evidently we're having some trouble hearing. You've already taken the AHSC class that was scheduled.
Yeah, the highway safety.
Yeah, the highway safety. And then you, in the next 2 weeks, are going to take the VIP class. Is that correct?
Yes.
All right. And the victim impact
He
class.
also indicated that he will be making a payment today for fines and costs. And Mr. Hanna and I agreed that this is fine for now, and we can set it for 2 weeks and review then.
All right. So that's a way to keep you to make sure you're doing what you're doing, and then we'll set it for 2 weeks. And if everything's looks good, then we can resolve.
Then we can terminate probation.
Terminate probation. All right. All right. So for the record, we will Brendan, just so I get it, all parties appeared. All parties appeared with probation agent Hannah. Defendant completed AAHC. Complete VIP in the next 2 weeks. 2 weeks. And you indicated that you're going to make a payment on fines and costs. On fines and costs today. We'll set it for 2 weeks, 2 weeks out. 2 week adjournment.
And we can review then if the best course of procedure is to terminate probation, or if Mr. Terry here would have not abided by.
All right. So if everything's good in 2 weeks, they're willing to look at terminating probation. All right. I need a hearing date. I'm not here in 2 weeks, am I? Oh, I am. Okay.
February 7th.
February 7th
At 1.
at 1 o'clock. And you'll get notice of that. Mr. Terry, I can tell you what, if you do everything you're supposed to in the next 2 weeks, it's going to be hard for them for Miss Williams and Mr. Hanna to say we're continuing probation.
Okay.
So if you want to get off probation, clear it up in the next 2 weeks, and then we can finish this. All right.
I got a question. Can
Sure.
I get a note for my job that's stating I was here?
You can get a notice that you were due to be here. We can give you a copy of that, can't we? Like a docket notice or something, or
it won't. It will have the reason why I'm here.
Most likely it will.
Okay.
Yeah. I don't know how to give you a note that you got to be in court without telling them why that you're here. Yep.
Right. Okay.
Yep. So that's the notice for the next one.
Okay.
Do you want a notice for today I'm telling you that you needed to be here?
Yes.
Okay. I think just a copy of this afternoon's docket with his name on it would do.
I can give him. Okay.
I got it. Okay. So what I'm saying, Mr. Terry, is you're really close.
Okay.
Yeah, you're really close. So
I'm gonna get it completed.
okay. All right. You're all set. I will see you in a couple weeks. Okay.
Thank you, Your Honor.
Ms. Williams, are you all set?
Yes.
Okay.
Sam, you are the sole owner, member, managing member of Sam Rental LLC, is that correct?
Yes.
And Sam Rental LLC is in the business of leasing residential real estate, is that correct?
Yes.
And as one of the properties that Sam Rental owns and leases is 3140 Fielding Drive in Lansing, is that correct?
Yes.
And that's within the city of Lansing?
Yes.
Now, I have here, if I may, Your Honor, do I have?
You want to have that marked?
Yes, please.
Okay. So I'll have that marked as plaintiff's exhibit 1.
It's 3104, not 3140. 3104 Fielding.
First of all, ma'am,
I'm sorry.
you can't say anything or we're going to ask you to leave. All right. All right. Do you understand?
I understand. I just wanted you to have the correct address.
All right. He'll have the chance to correct it. Okay. And Miss Becker's going to have a chance to cross-examine him. All right. But what we can't do is have people in the back yelling out whenever they want to. All right.
This is about the record. It should be right.
So there's plaintiff's exhibit 1.
Thank you, Your Honor.
You're welcome.
Sam, I'm now showing you plaintiff's exhibit 1, which appears to be a residential lease agreement, a total of 4 copies. And would you please identify that for me, confirm what it is, and maybe give me a little more detail as to who the lease is with?
Sure. This lease is between Sam Rental LLC and tenant Deborah Wilke, and the property address 3104 Fielding Drive, Lansing, Michigan 48911, and the lease was a month to month starting from January 1st, January 1st, 2022. It's a month to month lease.
Okay. And now, if we go to the last page, the 4th page, there appear to be what I would call electronic signatures on this lease. Is that correct?
Yes.
And can you identify for me, first of all, who has signed it as the landlord?
Yeah, landlord is signed by me.
Okay, as Representative Sam Rental LLC, is that correct?
Yes.
And what is the date of your signature on that lease?
On the 12/23/2021.
And then there appears to be a signature by DocuSign for the tenant. What is the date of that particular signature?
It's at 12/23/2021. Yeah.
And whose signature appears on that?
That's Deborah Wilke.
Now, I'm looking at that signature, and that signature, although it's not terribly easy to read, does not appear to say Wilkie.
Yeah, she changed her last name a few times. I don't know, once while during the lease, she married and she divorced. That's what now. Yeah.
Okay, well, Sam, first of all, let me just ask you this. Would you agree to me that it appears to be Becker as the last name here, D. Becker, as opposed to it being D. Wilkie? Would you agree with me on that?
Yeah, I agree with that.
Okay, but be it Wilkie or Becker, the tenant to whom you lease the property to is the woman here in court sitting at council table. Is that correct?
Yes.
Okay. Now, I believe you indicated that this is a month-to-month tenancy according to the terms of the lease, correct?
Yes.
Now, did you provide Ms. Becker Wilkie, did you provide her with notice of termination of your tenancy?
Yes.
And do you recall when that was?
That was in around August or July of last year.
Do you happen to have a copy of the demand for possession or a notice to quit in your file here?
Yes,
If I may, Your Honor,
You may.
if you could please pull that out for me.
And we'll have that marked. So you want this marked as People's Exhibit 2 or Plaintiff's Exhibit 2?
Yeah, yes, thank you, Your Honor.
Okay. All right, so this has been marked as Plaintiff's Exhibit 2. I would counsel both the witness and not to hit the mic as it ends up reverberating on the headphones.
Okay, very
So,
good.
Yeah, so yeah, the mic is right there on top. So if you hit it,
Yeah.
we're not able to record you.
I've got you. Thank you. Your Honor, first of all, I'm not sure that I offered for admission Plaintiff's Exhibit 1, the residential lease agreement. I would offer that at this time.
Okay, motion to omit Plaintiff's Exhibit 1, the lease. Any objection?
Yes.
Okay, what is the
Not
nature?
my signature. Your
What,
Honor.
it's not your signature?
It's not.
Okay, I'll allow you the opportunity to cross-examine on it with that understanding. Plaintiff's Exhibit 1 is admitted into evidence.
Sam, I'm showing you what has been marked as Plaintiff's Exhibit 2. Is that the demand for possession that you had served terminating the tenancy?
Yes,
And does it indicate when it was that you served Ms. Becker?
on the 8/1/2022.
And what was the method of service?
The first class.
Okay, very good. Your Honor, I offer Plaintiff's Exhibit 2.
Okay, so motion to admit Plaintiff's Exhibit 2, which is the notice to quit to that listed as Deborah Wilkie and all occupants, 3104 Fielding Drive, Lansing, Michigan, 48911. Any objection, ma'am?
No.
Without objection, Plaintiff's Exhibit 2 is admitted into evidence. And then I'll look at Plaintiff's Exhibit 1. I don't have that. Oh, that's the document that was just
Yes, Your Honor, excuse me. I took that.
all right, thank you. You may
There you go.
proceed.
Sam, since the time of serving the demand for possession on the defendant, which again was August 1st of 2022, have you received any rent from the defendant during that period of time?
No.
So you have not received rent for the month of August, September, October, November, December, and January. Is that correct? Now, who do you understand is currently residing on the premises at 3104 Fielding Drive?
I think her daughter, and she told me she's living 1 or 2 days over there.
So well, here. So first of all, you say her daughter. I assume that's Ms. Becker's daughter. Is that correct? Do you know what her name is?
I think Alicia.
Okay, and so you believe that she is residing in the residence. And did I understand you to say that Ms. Becker would stay there on occasion?
That's what she told me, but I never seen it yet.
Okay. Is anyone else there residing there to your knowledge?
No, I don't have knowledge.
Now, during the period of time that you have leased this property to Ms. Becker and it's been occupied by she and apparently her daughter and maybe others, has it been kept fit for its use that was intended?
Yes.
Has it remained habitable during that period of time?
Yes.
You believe that you are entitled to possession of this property based upon it having been leased to Ms. Becker on a month-to-month basis, and you're having provided her with notice of termination of that tenancy. Is that correct?
Yes.
I have nothing further, Your Honor.
Thank you. Okay, so you can ask the witness any questions that you'd like. Just place them in the form of a question.
Sam, did I or did I not, back in August, when you wanted to jump the rent $150, tell you that there were windows broken by a little boy around the corner, that he was mad because he didn't babysit him anymore. My daughter didn't babysit him
So
anymore?
so just one question at a time, but there's like three questions in that. There's three questions in that. Just one, ask one
Were
question.
you informed that there was a little boy who broke out 3 windows in the house? Plus the easement window. Were you informed, yes or no? And you said. Oh, excuse
Wait,
me.
hold, let him answer
I
the,
need to finish
let
the
him answer the question. Were you informed that there was a broken window from a neighborhood kid?
No, she didn't.
Your Honor, that's a lie.
Okay,
reason I'm saying
ma'am, just ask the questions.
Okay. We called you and told you that once again. the
Okay,
front-
that's not a question.
Okay.
You're making a statement.
I don't know how
You're
to
gonna
say
have plenty, you're gonna
How
have
can I
plenty
say
of
it?
times to make statements,
How can I
okay?
say it?
I
I made a phone call. We
What
made
you
a
want to
phone
say
call.
is a statement.
Ask him a question.
So you just need to ask a question.
Were you not informed that there was 1 2-bedroom windows, the easement window, and the front window again had been broken by this little boy? And you said that his
Wait,
father.
no, not what you said. Just ask him. Were you informed of that? Were you informed of that, sir?
No, not she.
Okay, so he's, the answer is no to that question. Okay, next question.
Were you not told by the, what do they call the inspector? To have the things that I gave them and the things that they
Wait,
inspected in the
now
house.
let's be specific. What,
Okay.
let's be
Put on a
specific.
he finished a new room in the back.
Okay,
As I was looking at
so
3
no,
3
just
months
give me
after-
one item, ma'am.
Oh, boy.
Do you have a list of items?
Oh, yeah. in
Okay,
my
where?
head. In my
Where?
head. Oh, they were right there on that phone.
I can't take exhibits on a phone.
All I can do is tell you then.
Okay, so ask him. I ask him as a question.
Did the inspector or did the inspector not tell you to take that hose out of the wall that was running across from the dryer and over around to the iron board and take the iron board out and follow into the kitchen where it ended up? Did you take it out or not?
Oh, you didn't tell me anything.
He said, he indicated he was not told about the hose.
Well, as I was standing right there, I'm just backing up. Did we call you and ask you if and tell you that the roof was leaking in Atiana's bedroom and there was black mold down the wall?
Uh.
Oh my God. Did we not tell you that the furnace wasn't working? Did we not tell you that the?
Wait, let him answer,
He
let
said
him,
no.
let him answer the question. So they did not tell you the furnace wasn't working.
Did we not call you not too long ago, it's been a couple months, and tell you that the toilet wasn't working again? And you said that you were not sending a plumber?
Okay, do you have any of this in writing? Any of these requests in writing?
No, because we talk on the phone. I have to talk.
Do you
to
have
on the
any
phone because I don't
evidence?
text
Do you have any evidence today that would
Only them
suggest?
pictures. Only some pictures, my daughter. I'm sorry. I know I can't speak. Can I say something? She's my witness.
You can consult with
Okay.
your daughter.
Come the maintenance man to the house. But I can't answer this. What about the duct tape on the ministry? Did you or did you not come to the house with the maintenance man and look under the kitchen sink and you guys cut a big hole, which is now why it's mouse ridden, and you duct taped it off? Oh my God, I'll get the maintenance man.
Ma'am, so
I'm trying to remind her. I'm
Right.
saying that he knows that he's under the house all the time.
you can't talk, okay? You can't testify, okay?
That's
So
what they told her.
She can, but not when it's her time to,
Oh, okay.
not just anytime she wants
Oh,
to.
okay. No, I'm just trying to refresh her memory. I'm sorry. Did you? Okay. Did you or did you not put a new dishwasher in, but it was improperly installed and it has not worked correctly since?
New dishwasher that was working fine.
So they put it, the response to your question is they put a dishwasher in and it was working fine.
For about 3 days.
Is that a question?
It worked for about 3 days, Sam.
But is that a question, ma'am? That's not a question.
Okay. Did we not tell you that it worked for about 3 days and that for some reason, just like the other one, it was plugged?
You didn't tell me.
Yes, I did. I don't know how to tell. He's just going to deny everything, so I don't know what to keep on going.
All right, you can your witness can take a can give a statement on your behalf. All right.
Okay.
Do you have any further questions for this witness?
No, because he's just gonna tell me no.
Any redirect, Mr. Now?
No, Your Honor, thank you.
Right. May this witness be excused, Mr. Now?
He may.
All right, this witness is excused. Sir, you're free to leave the witness stand. Mr. Now, do you have any further proofs?
No, Your Honor, I do not.
All
Thank
right.
you.
Does the plaintiff rest?
We do.
All right. Miss, you preferred Miss Becker, correct?
Yes.
Miss Becker, do you have any proofs today? Do you have any witnesses that you'd like to take the stand?
My daughter,
All right, so let's call her to the stand. What's her name?
Alicia Wilkie.
Okay, Miss Wilkie, you can come up. Once you get on the stand, I'm gonna have you take off your mask for recording purposes,
Yes.
okay? But I'm gonna have you state your name and spell your last name. Come on up here. All right, and your first name is?
Alicia.
And how do you spell that, ma'am?
ALEASHA.
Okay, and your last name?
Wilkie.
And how do you spell?
WILKE.
Okay, you have to raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right, I'm gonna have you have the seat right here. Now, for recording purposes, I'm gonna have you take off your mask so we can record you. And just be mindful that that's the recording device. So if you hit it, it doesn't record anything, okay? All right. Ms. Becker, you may proceed and you may have the witness, you can ask him questions.
Ms. Wilkie, is this or is this not my signature? Yes. That's the exhibit.
All right, so you want
Compared to that
to admit this as an exhibit?
Yes.
All right. And so I'm gonna have this marked as Defense Exhibit 1. All right. So it's been marked as Defense Exhibit 1. Did you want to move for the admittance of it?
Yes.
All right. Any objection to the?
No objection.
Okay. Without objection, Defense Exhibit 1 is admitted into evidence. I'll keep that for now. Ma'am, you do understand that if there is no lease, then you're on a month-to-month anyway.
I understand.
Okay, thank you. Just so we have the law right.
Okay. Ms. Wilkie, did you at any time speak with Sam about the heater, the furnace not working this year? Yes, in person. And this was when? End of October-ish? And what was it that he said about fixing it?
He didn't say anything. The next person I spoke with was the maintenance man. He had the maintenance man for a very short period of time. He's the only person that came and fixed anything. Mr. Sam was there and documented everything that needed to be done, including the furnace, broken windows and everything. He was there in person.
And was there any conversation between the two of you about him fixing it or not fixing it? Was there at any time him telling you that he was not going to get the windows fixed?
Yes, he said I would have to get the windows fixed because I knew the kid, which didn't make sense because the whole neighborhood knows the kid and I wasn't the only house with broken windows. And I'm a renter. Why would I have to fix the window?
Because the little kid got mad at you?
Yeah, but he did it to multiple houses. So even I just assumed it's because he was mad at me.
And did you ever have a conversation with the boy's father about them paying for the windows?
I made a police report and I gave the police report document with the docket number to Mr. Sam's maintenance man. When Mr. Sam came there, I also showed him the same thing. They took pictures of it. I told him that the police department told me that as long as it was under $6,000, that he wouldn't have to pay for a lawyer and he could charge the little boy's parents or sue the little boy's parents for the window. In person, I spoke with them and the maintenance man, a black guy. I wish I could remember his name.
at any time when we first moved there, at any time was there an inspector that came?
A city inspector, yes.
Was he or was he not told to take, what do you call it? It was a plastic pipe above the washer and dryer. It went through and came around to where the iron was at and somehow went down through the wall into the kitchen. Is that true that she told him to take it out?
Yes, along with multiple other things that were supposed to be fixed.
Was he or was he not supposed to at that time fix the deck in front?
Yes.
Had it been fixed in front?
No, the maintenance man that I just spoke of before is the one who fixed it. And he just fixed that. And I want to say it was October when I met this maintenance man. And after he fixed the few things that he fixed at the house, which was the first time my air conditioner had ever been fixed, the gutters were ever blown out. I never seen the man again. It was like he did too much work and was fired.
At any time, was he notified of the molding coming down the wall and the rain that had been coming in Oceana Spec?
Multiple times. And that was a brand new room that was built on 6 years ago when we moved in, which had no reason to be leaking. It's because it wasn't put together properly.
And because of his not listening, did he or did he not, when he was informed that he was told that the wall was being destroyed?
Yes.
Between the two bedrooms?
Yes.
And has he been to fix it?
No.
Are there many things that were supposed to have been fixed and he never came back and had them fixed?
Yes, it should have been because before
this big hole that's under the sink was not there when I rented that home. Is it there?
Yes.
And the maintenance man did what?
Taped it, duct taped it.
And the mice ate through.
That's under both bathroom and kitchens.
We never had mice.
Just ask the question.
Yeah, you're being given a lot of leeway here, so
I understand.
just she's under oath.
Yes,
She's
sir.
testifying. You're not testifying. So
She might be a big boy.
I have Parkinson's. I got a lot going on in my head.
okay. Well, I don't know what you expected was going to happen today. We
I'm-
set it for formal hearing,
Yes.
so
I'm sa-
this is the time that the court.
She had a hold of the paper that he had. sent.
Well, just so you know that, I mean, you were given notice from
I understand that,
December
Your Honor.
14th
I
that
understand that,
this
Your
was the
Honor.
time set for a hearing.
When in August, when Sarah stopped paying the rent, did he automatically jump the rent?
Well, when Sarah stopped paying the rent, she paid for the 18 months when they stopped paying the rent, he came to me, not my mother, and told me he wanted $12.50 a month rent. And I told him absolutely not. I wasn't paying $12.50 a month rent. We were never evicted in August. We didn't get an eviction notice until November. We've never had an eviction notice before that, ever. We lived there 6 years, always paid rent, never had an issue until he tried to up us to $12.50. And I said no.
Did rent begin or not begin at $9.50?
Yes.
And at a point when I was foster parenting your children, did he or did he not up the rent then? And said because it would cost more.
Just
Wait,
answer the question, you can't do
Yes.
that. Yes, the 10.
Was it because he said it would cost more for electric and gas?
Yes.
Is that my problem?
No.
Okay, have we ever been evicted?
No.
Has he always received his rent prior to Sarah?
Yes.
Since Sarah? Up to August.
Yes.
And did I or did I not tell him I was not paying $12.50? And did you not tell him that?
Yes.
That's it, Your Honor.
All right. Any cross-examination?
No, Your Honor, thank you.
Okay. May this witness be excused. Without objection, this witness is excused. Does the defense have any further proofs?
No.
Does the defense rest?
Yes.
All right. So I'll hear any argument you have concerning this matter.
Your Honor, I don't believe any valid defense was raised here to the termination of tenancy. Again, according to the terms of the lease, it was a month-to-month tenancy. Even assuming for a moment that the lease wasn't valid because of an inappropriate signature or something, then as the court rightly pointed out, we're still on the month-to-month tenancy at that point. Clearly, demand for possession was properly served on the defendant tenant. And now we're finally here today to make that determination as to whether or not the tenancy was terminated. I would like the court to find that it was indeed, enter a judgment of possession for the plaintiff, and accord the defendant and any other occupants of the property their 10 days to vacate the property.
Thank you. Response?
The only response that I have is, isn't it or is it not against the law to forge my name?
I'm sorry, ma'am.
That is not my signature, sir.
Okay.
That is not my signature.
Okay. So this is
Everything I
all,
sign, I sign
this is
Deborah
all part
and
of your
Becker.
argument.
I
which
signed
is-
Deborah and Becker, everything I signed.
Okay,
And I have perfect penmanship. My
okay.
mother was a school teacher. Sam and I have had many conversations, Your Honor, many. And he knows, he knew exactly what was going on at the house. He knew exactly what was wrong with that house and did not come to fix it. He would send a maintenance person every now and then. But the last one that he sent is the only one that really did what he was supposed to do. So, I mean, I'm saying, I'm not disputing. The rent's not paid since August. I'm not disputing that whatsoever. I'm simply saying that he's supposed to do what he's supposed to do per the city as well. And the city told me when I called the inspectors, they told me that he had called them and told them that it had been taken care of.
Your Honor, just so the record, I'm sorry, just so the record's clear, we're only seeking a judgment of possession, not a money judgment.
Right.
Only a
That's fine.
judgment of possession.
Right.
That's fine.
Anything else for your summation, ma'am?
How many days we have?
I haven't made a ruling yet,
Well, I'm requesting 15 if I can get 15.
but
If I
wait,
get 15
wait till my ruling and then,
Oh,
okay.
Just wait on this.
Wait till my
I've never
ruling.
done this before.
I know, it's okay. I understand that that this is a new arena for you. However, I must indicate for the record that you were explained that we're going to formal hearing, bring all your evidence, bring it away, the court can see it, it's tangible, so we know it, you know, and so that's what I'm making my ruling on, what's in front of me.
But what
It's
makes
the
me-
only choice I have.
Your Honor, what makes me so mad is I was told by another landlord, take your phone with you
Right.
that has all those pictures that you've already.
I
showed
would
me.
suggest that you don't get your information from other landlords, okay? Maybe talk to a lawyer, okay? Maybe talk to a lawyer.
Well,
In
I'm
this
not gonna have to
regard,
go to this again.
in this regard, the law is clear that if a signature is contested, which this seems to be contested, then I'm supposed to look beyond the document. I do have a signed document lease. The fact of the matter is that even if this lease doesn't exist, you're on a month to month. You're on a month to month.
And
So
that brings me to another point,
you're
sir.
30 days to 30 days legally, okay?
That brings me to another point.
Well,
He said.
I don't know who he is, and I don't,
Sam.
and at this point, I'm only talking about the law. I'm not talking about other people and what they told
I
you.
was told it was a 2-year lease again.
But you could have been told anybody,
Just
I'm
listen
not.
to the
yeah,
judge, okay?
and you probably shouldn't, you probably should get your information from somebody who knows the law, okay? So you, regardless, you're on a month to month. And what's required in a month to month, whether it's signed or not, is a notice to quit, which is valid. That's valid, August, and you have not paid months since then. And you've indicated that you refuse to pay months since then, you know, and that means that your non-payment of rent is going to get you evicted. All right. If you had come in court and indicated that this is not habitable in some way, that I can't live here, and brought proof of that, brought me proof, then I'd have some legal issue. But I don't have a legal issue because I have no proof in front of me. Okay, I have nothing to account for that. So I find by preponderance of the evidence that the plaintiff have made their case concerning possession of property for non-payment based on plaintiff's exhibit 1, 2, and 3, and the witness's testimony. Mr. Now, would 15 days suffice for the tenant to remove themselves?
Yes, Your Honor, 15 days would be sufficient. yes.
All right, so I am going to await an order from the plaintiff. So plaintiff proves their case by a preponderance of the evidence. A preponderance of the evidence after exhibits 1, 2, and 3 are admitted, and testimony of both the landlord and the daughter-in-law.
Daughter.
What's that?
Daughter.
Daughter, thank you. And that's Alicia Wilkes.
Okay.
So by preponderance of the evidence, the order will be submitted by the plaintiff. And as of the date I sign it, there'll be 15 days from that date, okay? So if I sign it today, it'll be 15 days from that date. If I sign it tomorrow, it'll be 15 days from that date. So it'll be 15 days from the date of the court signing.
Your Honor, does the court have a form available to?
I think there's one in the civil department, is there? I know there's one online, but I'm certain if you get it to the court this afternoon, by the time I get off the bench, I can sign it, and it'll be so I would plan on 15 days from today's date. By law, it's just 11. It's over 10 days. So 15 days. It says 15 days is extra time. All right, ma'am.
I understand, sir. I'm not disputing anything.
All right.
The only thing I wanted to know the 15 days for is because my daughter has to go out of state today, and she won't be back until that 10 days is up, and she's going to need that 5 days.
All right. So I'm going to return plaintiff's exhibits 1 and 2 to counsel. I'll return back plaintiff's exhibit 3, which is marked, but that's your driver's license. Is there anything else for the record? Docket 2202930, Mr. Now.
I have nothing further, Your Honor. I will get a copy of a judgment of possession, have that prepared. I would ask Ms. Becker if she wants to stick around to take a look at it and approve it as to form before I submit it to the court. That'd be fine.
Okay, thank you.
Does that mean he cannot enter the?
He can enter without you. He's doing it as a courtesy.
No, we're saying.
I'm talking about right now.
15 days is like he can't enter the house, all right?
No, you're allowed. It's your house for the next until 15 days after I sign the order.
He's walked in the house before without
Right.
permission. so I
As
can't-
long as there are tenants in the house, you can't walk in until you get possession in 15 days. All right, sir? All right. All right, that's all for the record. Thank you, Mr. Now, and thank you, Ms. Becker, for your appearance. 2202930. That's all for the record.
Okay, great. Thank you.
So let's see on Miss Whitty's case. Because I think, do we have Mr. Sarah here? That'll be a complete. So Miss Whitty, we have a hearing. So anything but I don't, is there a Thomas Foltz or an Irma Foltz here?
Yes, Your Honor, we're here.
All right.
I'm here. My husband couldn't make it out of work.
Miss Whitty, do you know if this is going to be a hearing or not?
I do not know.
All right, Ms. Foltz, is this going to be a hearing today?
Well, from what I understand, Miss Dunlap is willing to go to mediation. So I spoke to the mediation people and they said that the court would have to order that. We couldn't just go in ourselves. Ms. Dunlap also tried to contact them and they said that the court would have to do it.
So
I talked to Mr. Rosa about it too.
My client is shaking her head no. They
Yeah,
would not like it to go to mediation.
so it only goes to mediation if both parties want to go to mediation, and the landlord's party does not want to go to mediation.
Oh, I thought I spoke to her last night and okay.
Is there, is there a Miss Quiroga here?
It's like the lady trying to talk.
What's that?
The lady trying to talk on Samsung.
Samsung. I don't see a
The
Samsung.
right one is Linda. Yes, it
That's
is.
her. Okay, all right, thank you. Yeah, that is her.
Oh, okay. 'Cause that's Miss Quiroga.
Yeah.
Have you had the opportunity to speak to either one of those
No,
people?
no, they've been
Would-
on Zoom. I've been here.
Would
so-
you, so I'm gonna have Nathaniel place you on an iPad so you can see
I would
if,
love that.
yeah.
Yeah.
So if you can talk to them
You bet.
and then he'll come back in and put you on in a breakout room with one at a time. All right.
Okay.
I just don't want you waiting if
Oh,
you're,
no, I appreciate that. And
okay.
I have 3:30s in front of Buchanan. so
all
this
right.
is Great. Okay.
All right. So Miss Quiroga and Miss Foltz, I'm gonna have the attorney meet with one at a time in a breakout room so that you can see if you can resolve this. This is the time set for hearing, and I want to make sure if we're in hearing that you're doing something, so to speak. All right. So we'll go ahead
Yes,
and we'll let Nathaniel place those on, and I'll call a different case. All right.
Okay.
First, Mr. Bach, you're here on the LAFQ case.
No, sir. Sorry, that's just
West Jolly LLC.
yeah, I've got two. One is West Jolly LLC, the other one is Pleasant Grove LLC.
So I'm going to go ahead and call your case, Mr. Bach, and we'll go ahead and we'll put that first case you have. I'm calling the case docket 2202-842. That is West Jolly LLC versus Dennis Stenson. Will the parties please introduce themselves for the record?
This good afternoon, Your Honor. Ronald Bach here for West Jolly LLC plaintiff.
All right. And this is the time set for a hearing on this matter and a non-payment. I will indicate that in a previous pretrial, Mr. Stenson failed to appear. There was service by attachment, and we had a fail to appear as a defendant. Therefore, we set it for hearing today. Once again, Mr. Stenson's failed to appear. How would you like to proceed, Mr. Bach?
At this point, I request a default judgment tender, Your Honor.
All right. So I will indicate that I will grant you a default judgment. And you'll follow that up with an order, Mr. Bach?
I do. I have that prepared right now. I just deleted the part about the money judgment and checked box number 7 that says no money judgment entered at this time. And I will email that to the court.
Yes, I have. Did you want to put any numbers on the record, Mr. Bach?
Sure. Right now, we've got rent to retain is $1,472.64. Cost with the filing fee, the process server, and the statutory attorney fee is $212.12. Total amount to retain possession, $1,684.76. I've got the writ date of February 2, 2023.
February 2nd, 2023. That will be, if you get that to me today, I'll sign it today. If not, it'll be 10 days after when I sign it, might be tomorrow. Okay, Mr. Bach?
Understood, Judge. You should have it very soon.
All right. Anything else for the record, docket 2202-842?
No, sir. Thank you very much.
All right, thank you. That's all for the record in that file. We have Lucero. So I'm going to wait on that hearing until we look at some of our 215s. Mr. Bach, you're here on Pleasant Grove LLC and Anthony Scott.
Yes, yes, sir.
Sure. Oh, this is Mr. Nouns. So on the record in docket 22-02843, that's Pleasant Grove LLC versus Anthony Scott. And Mr. Bach, your appearance for the record.
Yes, good afternoon, Your Honor. Ronald Bach here for Plaintiff Pleasant Grove LLC.
And I'm looking for Anthony Scott in the Zoom courtroom, and I do not see him. I'm looking, is there an Anthony Scott in the physical courtroom? So this was set for 2:15. It is now 2:41. I will indicate for the record that this was in a previous pretrial, December 14, 2022. The defendant failed to appear. There was service by attachment, and therefore we've set them both for today's docket. Mr. Bike, how would you like to proceed?
I request a default judgment to enter, Your Honor. I've got the amount of rent to retain is $3,225 costs with the process server filing fee and the statutory attorney fee of $250.12. Total amount to retain possession is $3,475.12. I do also have in my records that only one of the defendants, Anthony Scott, was personally served. So I did fill out the money judgment portion. I took out 8 days of rent to represent the remaining portion of January. So the rent to remain, I guess that amount damages $2,999.24 with the same $250.12 in costs. So the money judgment against Anthony Scott only, not Letitia Garza, would be for $3,249.36.
As to Letitia Garza. Is that correct?
Only Anthony Scott for the money judgment.
Oh, that's right.
He was personally
As to
served. She
Anthony
was not.
Scott only. And you'll follow that up with an order in regard to both of these defendants?
Yes, sir. They should be in about 15 minutes. I just have to fill out the default forms.
All right. Order to follow. All right, so that's all on the record in docket 22-02843. I'll await that order. And that's all on Pleasant Grove LLC versus Anthony Scott.
Thank you, sir. You have a good day.
You too. Mr. Landon, you're here on Rio Town?
Yes, Your Honor.
All right. It's on here. So yeah, Nathaniel, if you can turn that up just a tiny bit, or. All right, so we're on the record in docket 22-02924 Rio Town Apartments versus Juan Quisada. Will the parties please introduce themselves for the record?
Jeff Landon on behalf of the plaintiff.
Okay, and sir, you are Juan Quesada?
Yes.
All right. And Mr. Quesada, I have you as you was not here on December 14, 2022. Mr. Landon, have you had the opportunity to speak with Mr. Quesada on this case?
I have not, Your Honor.
All right. This is the time set for formal hearing today, in which we take proofs in regards to whatever landlord tenant issue is at hand. I have you failed to appear on the 14th, and now on the 23rd you're here. We reset it for the 23rd. Was it your plan to go forward with a hearing today, or did you want to speak with Mr. Landon?
I had no recollection of the 14th case, so my dad was scrolling the court cases and he just stumbled upon this one. And so
All
I
right,
talked
so
to
you're,
the lawyer.
so you talked to a lawyer, or would you?
Yeah, I have a lawyer, and I just asked her, like, you know, because I have another case going on, and I thought it was in relation to that one, but it wasn't. So
So who is your attorney?
Ina O'Brien.
Ina O'Brien. Mr. Lannon, have you had any conversations with Ina O'Brien in regards to this file?
No, Your Honor, I haven't had any communication with anybody on behalf of the tenant.
Excuse me, Judge. I don't mean to interrupt, but Ms. O'Brien is his representative in a separate matter, not in this particular.
All right, I'm just trying to figure out, he doesn't have a lawyer today.
No.
We're set for formal hearing today.
Yeah, he did not know about the 14th. He did not get no notice or anything prior, you know, like that. Like you said, I was strolling around, you know, in the courts, you know, online, and I stumbled across his name. And that's when we noticed, you know, that it was today.
Are you still living at 300 East Malcolm X Street, apartment 218, Lansing, Michigan?
No, Your Honor, I haven't lived there since August last year.
Well, Mr. Landon, it appears that he's not in the Malcolm address residence that notice was sent to originally, although I have personal service, but that's in 2022 of that address.
The current case is posted.
Oh, the current case is posted.
And I believe that there might be some possessions. That's why we're here today. Maybe he would surrender everything. I'm not sure.
Mr. Quesada, have you had the opportunity? Would you like the opportunity to speak with Mr. Landon concerning this case? Because this is the time set for formal hearing, and I'm wondering what you want to do today. And I know Mr. Landon is going to ask for possession of the property.
Oh, yeah. Yeah, I feel like that's reasonable. I haven't lived there since August.
So you have not been in possession of that, what, Mr. Landon, what's the nature, what's the apartment address that we're dealing with here?
300 East Malcolm X Street, apartment 218.
And you don't live there anymore?
No.
No. So you don't have any objection to granting possession to Mr. Landon?
No.
There is a supplemental complaint for a money judgment, Your Honor.
All right, so there is a supplemental complaint for money judgment concerning this matter.
With that, I was talking to the management there, and I believe in September we came to an agreement, and ever since then, you know, my life's been a little wacky, so I haven't really had, you know, the funds to pay it yet or get it paid.
Was that $755 per month claim?
Yes.
Okay.
Yes.
So you readily admit that you've not made any payment towards a supplemental damage, is that correct?
Yes. For the first month, I believe until October, I paid about $400 or something towards it. I think it was $3,200 total. And somewhere around there, I was just spitballing. But I paid that, and then after that, I had to, you know, take more days off of work to focus on the case that I'm going through, that I was going through.
Your Honor, could we be put in a breakout room and maybe we could have a discussion?
Yeah, I think that's what I'm going to have to do. The iPad is being used up, but as soon as the iPad becomes available, we'll place yourself and Mr. Quesada in a breakout room. All right, Mr. Landon?
Thank you, Your Honor.
All right, thank you. Go ahead and have a seat back there. And once I'm going to put you in a breakout room with Mr. Landon, and you can start to figure it out. Okay?
Thank you, Your Honor.
You're welcome.
Your Honor,
Who just said Your Honor?
Ms. Kroga.
Yeah, you're the attorney who's supposed to meet with you is still in a breakout room, ma'am.
Okay, because I didn't know what was going on. I'm sorry.
Right. So you're supposed to meet with Miss Whitty, and she's still in a breakout room. So if you stand by, well, once she's done in her breakout room, she'll also meet with you. Okay, ma'am?
Okay.
All right. How about Mr. Is there anybody here representing 1340 South Waverly?
Yes, Your Honor, I'm the property manager for there and our attorney, Rhonda Kunkel, is here.
Okay. So that's 2962926. Because once we start that hearing, it's going to take some time. So, all right. So I'm on the record in docket 22-02926. That's 1340 South Waverly versus Lynetta Felicia and Michael Williams. This is the time set for a formal hearing today. Parties, your appearance for the record.
Good afternoon, Your Honor. Rhonda Kunkel appearing in place of David Burrick this afternoon on behalf of Foxland Holdings, and our client Mary Jo Schmidt is here from Foxland Holdings.
All right, and ma'am, you are Lynetta Felicia Williams and Michael Williams. I'm sorry, you're gonna have to unmute yourself.
Okay, yeah.
All right. This is the time set for a formal hearing today. And Mr. and Miss Michael Williams and Felicia Williams or Lynetta Williams, you are not represented by counsel today?
Well, he was supposed to be here, but we thought we were going to be able to come in because we evidence that we wanted to show you, but our car is not going to be able to make it.
What is the name of your lawyer?
It was from Legal Aid. It was from Legal Aid. His name is Greg Cor. I don't know his last name. It starts with a K.
But we're usually familiar with Legal Aid. Let me check to make sure that they have you, because I have nothing in the file that Legal Aid is representing you. I do have that you met with Legal Aid on December 14th, but I have no appearance from them. And generally they provide us with an appearance.
Okay.
And we have nothing that would indicate that they're representing you. Is there anything in the computer? What they told you that you're being represented?
Yes. Yes.
All right. I'm gonna have you stand by. We're gonna contact Legal Aid to see if they're representing you in this matter. Okay.
Okay.
All right.
Thank you.
Ms. Kunkel, stand by, and we're gonna send an email to them to see if we have any representation.
Thank you, Your Honor.
You're welcome. Did you want to meet with Miss Kuroga? All right. Okay. How about Miss Kuroga? Because she's right there.
That's who I put the break out. She didn't join.
All right. Now she did. Did you just put her there?
Oh, there she,
Okay.
there she is.
Yep. So you're all set,
I'm gonna
ma'am.
head back down the hall.
Yep.
Huh? Legal Aid and
Letitia Williams and Michael Williams. If you could email Miss Pereira or whoever to see, they indicate that they're being represented. And I don't have. Ms. Foltz, there's no smoking in the Zoom courtroom. Mr. Keski, we're there. We're gonna call your case on Lillian Sherrod.
That's
All right.
fine. That's fine, Your Honor.
All right, so we're on the record in docket 22022906. That is Rent Fix Management LLC versus Lillian Sherrod. Will the parties please introduce themselves for the record?
Good afternoon, Your Honor. Don Keski for plaintiff, and I believe Mr. Kip Wilson, agent for the owner, is also online.
All right, and I see Mr. Wilson. Do you see Lillian
afternoon.
Sherrod in the Zoom courtroom? I do not.
No, Your Honor, I don't see her.
All right, is Lillian Sherrod present in the physical courtroom? All right, this was scheduled for 2:30. It is now 2:56. It would appear that the defendants failed to appear for the formal hearing. Mr. Keski, how would you like to proceed?
I think, Your Honor, we would like to proceed with a default judgment. This is the second
All right.
hearing.
Yeah, I have this as a failed to appear, and it was set for today because of notice of service by attachment. Do you want to place any numbers on the record, Mr. Keski?
Yes, Mr. Wilson could provide those numbers.
All right, Mr. Wilson, do you have any numbers you'd like to provide for the record?
Yes, Your Honor, I do. For possession judgment, we have rent in the arrears of $642.72. Costs $222.28 for a total of $865 even.
What was the first number, Mr. Wilson?
642.72.
Okay. I did not write that down correctly, and that makes much more sense. All right. So I have a full redemption amount of $865.
Yes, Your Honor.
All right. Any other numbers you'd like to put on the record?
No, Your
Mr. Wilson,
All right.
did you want to put a money judgment on the record or not?
I don't believe we had service.
Yeah, I don't believe that.
I see. Okay.
All right. All right. So I will wait for the order to follow the file. And possession will be great. Go ahead, Mr. Keski.
We'll try to email that to you this afternoon, Your Honor.
All right. The writ of eviction in regards to the court's address. It'll be 10 days from when the court signs it. If I sign it today, it'll be 10 days. If I sign it tomorrow, it'll be 10 days after that. It'll be exactly 10 days from my date of signature. It should be no sooner than tomorrow. So, but just so you understand that. All right. So order to follow the file on possession. Anything else for the record, Mr. Keski, on 22022906?
No, Your Honor. Thank you.
All right. Thank you. That's all for the record, 22022906.
Okay.
Thank you, Your Honor.
Thank you. And then is there a representative from Philip Dean Apartment?
Yes, Judge. Good afternoon.
All right. And is there I'm not sure I have this name right. Kerr Bullock?
I just want you to be aware.
Kerr Bullock? All right, Ms. Wilburn, I'm going to go ahead and call your case, okay?
Very good, Judge. Thank you.
All right. So we're on the record in docket 22022946. That's Philip C. Dean Apartment versus Kerr. No, that's not right. Nine two six. All right. Had the wrong file there, Ms. Wilburn. I'm sorry.
No problem.
So we're on the record in docket 2203-296. That's Philip C. Dean Apartment versus Occur Bullock. Ms. Wilburn, you've placed your appearance for the record. It appears Mr. Occur Bullock, I do not see in the physical courtroom or the actual courtroom. This was scheduled for 2:30. It is now 3:01. It appears the defendants failed to appear for the formal hearing. I would indicate for the record that the defendant had previously failed to appear on December 14, 2022, with service by attachment. Ms. Wilburn, how would you like to proceed?
Your Honor, I would be requesting a default judgment today. This is a termination case. Defendant failed to timely recertify. To my knowledge, defendant still has not recertified, so we would be requesting possession only judgment today for the statutory 10 days, which I believe takes us out to February 3rd.
Correct. Are there any numbers you'd like to put on the file, ma'am?
There are not, this is not non-payment, it is termination, so there are no
Okay.
money amounts.
So I will grant your default judgment. And the order will be signed either today or tomorrow, and then it'll be 10 days from that signature. Anything else for the record on docket 2203-296, Ms. Wilburn?
Nothing from me, Judge. Is it Judge Flores courtroom? Is that the appropriate email to send it to?
Yes, it is. If you
Very
send
good.
it there, then I'll get it and sign it.
Very good. I will send that in shortly, Judge. Thank you. Have a good
All right,
afternoon.
thank you. That's all for the record, docket 223296. All right, so let's go. That's 1340 South, great, isn't it? 2924 2926 2926. All right. So we're back on the record in docket 2202926. That's 1340 South Waverly. And Felicia Williams and Michael Williams. I have a note for the Williams that Mr. Cozart indicated that because of the delay in contact, they would not be able to represent you today after they talked to you this morning. They might be able to discuss the case further, but that they were not going to be able to represent you today because you spoke to them just this morning. Does that sound right, Ms. Williams and Mr. Williams? Can you hear me? Lynetta Williams and Michael Williams? Ms. Kunkel, we lost the Williams.
No, it doesn't.
I think they are.
Oh, there they are.
I don't see
There they are.
video,
Yes.
but I think I heard them.
Right. So you are not represented by counsel today. Would you like to speak with Ms. Kunkel and Ms. Schmidt in a breakout room to see if you can resolve some of these
Hello?
issues?
That
Mr.
would-
Williams? Mr. Williams, can you hear me?
Yes. Sure.
That's fine.
All right. Ms. Kunkel, would you be amenable to meeting with the Williams in a breakout room?
Yes, Your
I
Honor.
don't know what's going on.
All right. And I will also put Ms. Schmidt in there too as
Thank
a property manager. Thank you. Who are? The Williams? All right. What's that?
I'm gonna let Ms. Kunkel know. Try to pull them out of the break. I know she's got them now.
All right. Ms. Kunkel, we lost the Williams.
We kind of wondered about that when we were asked to rejoin.
Yeah, we seem to have lost them. And they don't have counsel. I have them as appearing, but then leaving. Stand by for about 10 minutes and then we'll put it on the record, okay?
Thank you, Your Honor.
If they're truly having technical difficulties, we want to make sure and to be accountable for that. But if they've just left, then that's different. All right, ma'am?
Yes, thank you very much.
Did explain that they contacted him last Thursday and that they followed up this morning. So the first contact wasn't this morning, it was last week.
Okay, I think they're back. Miss Williams, is that you?
Yeah, we're back.
All right, I'm gonna go ahead. Yeah, we held on just a bit to see. I'm gonna place you in a breakout room with Miss Kunkel and Miss Schmidt, okay?
Okay.
All right. For 6 and for 7 are wedding cases. All right, so we're on the record in docket 22-02192. That is Elena Watkins Living Trust versus William Ringo. And this is the time set for a formal hearing in the matter. It's been previously noted that possession was to take place between the two parties. First of all, this court is familiar with Elena Watkins and with Mr. Ringo. Possession was supposed to take place on December 27th, 2022 at 5 o'clock. In regards to possession being granted to Miss Watkins, we set it for review on this date and nobody's appeared. This was scheduled for 2:45. It is now 3:09. And therefore, no party appeared. And I'll just take a quick look of the Zoom courtroom and the actual courtroom. And with that understanding, the case is dismissed. I'm assuming neither party just decided not to back this. So there's that. And Mr. Mashney, you're here on the Kadwa Tafor case?
Yes, and Mr. Kane, it looks like he's on there, but I spoke with him and I think we have a resolution. If we could have I can call him or put in a breakout room, we can finish up the details.
It might work because I got a little line for the iPad. So if you could call him.
Yeah, I'll give him a call.
All right. Oh, they're on Zoom right now, but they're on Zoom, but you could still call them and then just let us know what you've come up with.
Okay, I will. Thank you.
All right. Thank you. Miss Noy, Miss Noy, what case are you here on?
Your Honor, she's my property manager.
Okay, perfect. Thank you. And Miss Kesey, Monica Kesey, what case are you here on? You're gonna have to unmute yourself, ma'am. You're.
Okay, I'm on Brittany Lucero.
All right, all right. All right, well, let's go ahead and start that case. That case was scheduled earlier. We're trying to move some cases for the docket. So you can come up here.
Yes, sir.
All right. We're on the record in docket 22-01381. And that is Brittany Weaver and Travis Winters versus Brittany Lucero. Will the parties please identify themselves for the record?
Brittany Weaver.
Okay, and sir, you are Travis Winters?
Yes, Your Honor.
All right. And ma'am, you are Brittany Lucero?
Yes, Your Honor.
All right. This is the time set for a hearing in this matter. And we scheduled it out for the purpose of my understanding there were other hearings going on in Arkansas. Is that the state we're in?
Yes, it was adjourned.
Okay, it was adjourned.
Yes, for the custody case, yes.
All right. Well, this seems to be the remnants of a custody case on some level. I also wanted to take is Miss Kesey your witness, Miss Weaver?
Yes, she is the process server.
Okay. And I asked for the process server to come and testify in regards because I wasn't sure from K9 Process Services.
Yes, sir.
That Miss Lucero had been served for the show cause date. That was the defendant failed to appear. And what date was that?
The service was done September 10th, 2022.
September 10th, 2022. And you did serve Brittany Lucero at the residence of 807 Northeast Benton.
Yes, sir.
And that was in regard, and then there was a fail to appear after that, if I remember correctly.
Correct.
The fail to appear was on September 26th.
Correct.
And then we show caused him from there.
Correct.
All right. Miss Lucero, you indicated you were not served at that time. So my question for you is, we now have the service processor who indicates that you were served on that day. How do you respond to that?
Not true.
So you're indicating that the process server did not serve you on September 10th?
Yes, Your Honor.
All right. Well, we are all here now and we're going to have a hearing, all right?
Okay.
We're all here now and we're going to have a hearing in this regards. I find that you were served, you are here, and I'm going to start taking testimony regarding these proofs. We don't have any lawyers involved. So it's a preponderance standard in a civil case that comes from district court. Miss Weaver, are you ready to proceed today?
Yes, Your Honor.
All right. Mr. Winters, are you ready to proceed?
Yes, Your Honor.
All right. Can Miss Kesey be excused?
Yes.
All right. Miss Kesey, you're free to leave the Zoom courtroom. Thank you for your appearance.
Thank you, sir.
Okay. Miss Lucero, are you ready to proceed today?
Yes, Your Honor.
All right. Miss Weaver, you may call your first witness.
Travis Winters.
All right. So you're going to call Travis Winters. All right. And Mr. Winters, I'm going to have you unmute yourself.
Yes, Your Honor.
All right. I'm gonna have you state your full name and spell your last name for the record.
Travis Winters, Winters.
All right, and raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth on a penalty of perjury?
Yes, Your Honor.
All right, what I'm gonna do is allow Miss Weaver to ask you some questions in direct examination, and then Miss Lucero can ask you some questions on cross. All right, sir?
Yes, sir.
All right, Miss Weaver, you may proceed.
Mr. Winters, what is the reason we are suing Brittany in small claims or civil?
It started out in small claims, so.
Small claims,
But it's now been removed to district court.
correct.
We are suing her because of damage and stolen property that Miss Lucero has taken.
Okay, I have the amount that's being requested at the maximum amount, which is 6,500. Is that correct?
Yes.
Yes, Your Honor.
I have in the file, there should be a list of items.
I've seen the list of items concerning that were attached to the original small claims complaint about various items. And if you want to, I can go through that for the record to make sure that the record indicates that those are the items you're suing that are the subject of the suit.
Yes, I do have a few other items that I can add.
All right, let me start. I have as a part that was attached, the Kindle 10, a Kindle 10 with green case and Apple iPad, a PlayStation 5, a Ninja coffee maker, a PlayStation 4, a 75-inch Hisense TV, a Nintendo Switch console, a Unicorn Diamonds poster made for Paisley by plaintiff Travis, a dress bought for wedding for defendant and children and never worn, a Dino outfit my deceased mother grandma bought for granddaughter, an urn necklace with grandma's ashes that was broke during a DV incident, a baby Brezza, a sharp tie blanket made for Ivy, a tie-dye outfit for Paisley that was in memory of grandma, an Easter baskets made for the girls that I purchased, a Graco swing and bouncer bought by my grandmother, a jewelry box that was late grandmother's, Scentsy buddies for granddaughters, Warmies for granddaughters, Arkansas Razorback blanket, and weighted blanket gray. You wanted to add to that list?
Yes, well, not add to it, but evidence that we have gotten, like the receipts of the items that were purchased.
You indicated all those items have already been purchased and been been in the custody of somebody else.
Correct.
Those are all used items.
Correct.
That's correct.
Correct.
Okay. So yeah, if you have receipts that you want me to look at, I'm happy to look at.
These are a few of the receipts.
Now, you're saying that you gave those and that those were stolen from you.
Correct, she was.
All right, so I'm gonna have you ask Mr. Winters some questions about how those changed hands. So Mr. Winters, you can unmute yourself and Miss Weaver can ask you questions concerning how those items changed hands.
Yes, Your Honor.
Travis, when were the items removed from Michigan? Or why were the items removed from Michigan?
The items were removed from Michigan because of the result of a DV incident, because I would not return the children to her after we have been going to court and no one demanded or told me I had to give the children back.
All right, so let me get this right. This is a custody battle, correct, Mr. Winters?
Yes, Your Honor.
All right, and you are the father of some children with Miss Lucero, is that correct?
Yes, Your Honor.
What are the names and dates of the children?
Paisley, Kathina Winters.
Okay.
She was born
Paisley Winters, and what's her date of birth?
8/5 of 19.
8/5 of 19. So she would be 24 years old?
Why'd you say 19? 8/5 of
2019.
2019.
Oh, yeah, 2019.
8/5 of 2019.
Correct.
So that child would be roughly 4 years old.
3. She'll be 4 in
August?
Yes.
And that's Paisley.
Correct.
Yes, Your Honor.
And what is the second daughter's name?
Ivy Mae Winters, born 10/11 of 2020.
2020.
Yes.
And that's Ivy Winters.
Correct.
Yeah.
And she would be 2 years old. She just turned 3.
2.
2. She just turned 2. All right. And were you and Miss Lucero married at any time?
No, Your Honor.
All right. But you're both parents of these 2 children. Is that correct?
Yes, Your Honor.
And then Miss Lucero left the state of Michigan and went to Arkansas. And that led to this small claims case. Is that correct?
Yes, Your Honor.
All right, you can continue with, I just want to make sure I got the names and you may proceed.
Travis, Mr. Winters, the items that have been purchased, who purchased them?
It was between me, my mother, and my deceased grandmother.
Where was a lot of the items purchased from?
Michigan and Arkansas.
Okay, so let me ask you this, Mr. Winters, how did they get into the cassette? How were they turned over? How were the items that were bought turned over to Miss Lucero?
Can I answer that?
When the whole incident happened, Miss Lucero and me, she decided to pack her stuff and move to Arkansas. And in the result, she took a lot of my belongings.
All right, so and these were part of the belongings that she took to Arkansas?
Yes, Your Honor.
Correct.
All right,
Only item that we've gotten back.
wait, hold on. Go ahead and talk to Mr. Winters. Do you have any more questions of Mr. Winters concerning, and you can piggyback any questions that I've asked.
Was there text messages made between you and Miss Lucero stating that she was going to return items such as the iPad, the Kindle, grandma's the swing?
Yes, there was.
And I believe you have them text messages also.
I think they were attached to the complaint.
Did we ever receive, or Mr. Winters, did you ever receive a message from one of Brittany's ex-boyfriends stating that she sold your PS5 that you have a lease with through Aaron's Rental?
Yes.
Do we have did the gentleman send us a receipt with her signature on it?
Yes, he did.
And I believe you also have that. I have no further questions for him.
Ms. Lucero, do you have any questions of Mr. Winters?
Yes, I do.
All right, you may proceed with your cross-examination.
Thank you. Mr. Winters, where was the items purchased at?
Most of them were purchased in Michigan and Arkansas.
What was purchased in Michigan?
The Dino outfit, the PlayStation. I can't remember exactly what all was purchased in Michigan.
I can answer that.
When you take the stand, you'll be able to, yes.
What was purchased in the state of Arkansas?
There was a TV, PlayStation 4, a Nintendo Switch, and I believe that is it.
Okay. That's all the questions that I have, Your Honor.
All right, thank you, Ms. Lucero. Ms. Weaver, did you want to testify today?
I can.
All right, it's up to you. It's your case.
That's fine.
All right. So I'm gonna have you testify from exactly where you are. You don't have any further questions for Mr. Winters?
No.
All right. So, Mr. Winters, you're excused as a witness. You can stay as a party. Ms. Weaver, I'm gonna have you state your name and spell your last name.
Brittany Weaver, Weaver.
All right, and I'm gonna have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
All right, you may proceed. You can make a statement in regards to your case.
So I guess the biggest statement is a lot of these items were items that I had purchased for the grandchildren. And I would like them back, so when my son has visits with them, he can have them. The iPad
So
was,
let me just get this right. You purchased them for the grandchildren, and now that they're not together, you only want the children to see those items when your son sees those items.
when they're with their father, yes.
Okay. So did you actually purchase them for the
Yes.
grandchildren, or did you purchase them for Mr. Winters?
Both, I guess.
Okay.
They
All
were
right, just clarifying, just
Yeah.
clarifying, okay.
There are items that, of course, I don't have receipts for that were bought by my deceased mother.
Right. And you understand, I can't give you any damages for sentimentality.
Right.
Purchase. It truly, it's what a buying seller will give a buying buyer for a used item.
Okay.
That's what you get today.
Okay.
Okay. You don't, if you want something else, you got to go to a different court. Because what I'm going to give you is, I don't give you sentimental value unless you provide me with some expert to tell me that. Okay. All right, continue.
I believe I gave you receipts for everything that you would need.
All right. There's some pictures here I've not, that were brought to the court's attention, because I know we've done a lot of through Zoom on July 8th. Did you want the court to look at those photos?
I don't know what photos they are.
All right. I've not looked at them. Ms. Lucero, did you provide the court with any photographs for the court to look at?
I provided bank statements to Nathaniel. He received them.
Right.
I never received
Yeah.
that statement.
Okay. All right. Ms. Weaver, do you have any further proofs?
No, Your Honor.
All right. Ms. Lucero, do you have any proofs do you have any, does the plaintiff rest in this matter?
Yes, Your Honor.
All right. Ms. Lucero, do you have any proofs in this case?
Just a bank statement. I don't know. I have all the items in my house. That is correct.
All right. Did you want to make a statement today? I'll swear you in and you can say something under oath.
Yeah, I can do that.
All right. So please state your name and spell your last name for the record, and that's really for recording purposes.
Okay. Brittany Lucero, Lucero.
Okay. I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right, Ms. Lucero, why don't you make any statement you'd like to make to me, and then I'm going to subject you to cross-examination of Ms. Weaver on the statement you make. But go ahead and make any statement you'd like to make concerning, and I guess what I'm really interested in is how did these items get in your possession? And then there's a small claims based on the amount for the items. I guess that's what I'm looking at, and I guess that's what I'm most interested in.
Okay. I moved to the state of Michigan of 2021 of October due to the fact that me and Mr. Winters were reconciling together for the custody case of the children. I did purchase the TV, the 75-inch TV in the state of Arkansas, along with the stuff that I have. His mother did purchase some outfits for the kids when they were born. And that she also purchased some outfits as Paisley was getting older. Unfortunately, I did leave the state of Michigan of January 14th. They filed the small claims when I got back into the state of Arkansas, but everything I left for them was inside that apartment in Michigan. I did take my 75-inch TV. I did take my bed that I own. I did take my kids' stuff because that was my kids' things. The tablet I did take due to the fact that it's underneath my Amazon account. We just traded it in to get a bigger tablet for her. And unfortunately, Paisley does use it at my house. And I purchased Ivy a tablet with my own money for the Amazon account as well. I did have the PS4, which I purchased in 2020. As you can see, if you have the bank statements, I did purchase it in 2020 with my Lily card. And then that was the pandemic money. And then when me and Travis split twice, one was in 2021 and the other one was in 2022. And fortunately, Travis didn't want any of the items of the home in 2021 when he picked up and left his dad's in the state of Arkansas. But now I don't understand is that when we split of 2022, they want to sue me for all these items when Travis knows in his heart that I have purchased some of the items as well.
All right, Ms. Lucero, is there anything else you'd like to say to the court?
No, Your Honor.
All right. Ms. Weaver, you have any questions of Ms. Lucero?
No, Your Honor.
Okay. All right. No cross-examination of Ms. Lucero. Ms. Lucero, do you have any further proofs today?
No, Your Honor.
All right. Does the defense rest? Ms. Lucero, you broke up there for a little bit. Does the defense rest in this case?
Yes.
Okay. Ms. Weaver, summation?
I guess I would personally like the property back versus the money. That's I would rather have the property back. There's items that we're still paying for, or that, I'm sorry, Mr. Winters is still paying for, that she has sold. I just don't think that's fair. And there's items that she took that she knew were sentimental value. She knew that they meant something to us and that we wanted them back because they were going to be handed down to other grandchildren. I just think what she did was wrong.
Ms. Lucero, do you have any summation for the court to hear before the court passes sentence? Or before the court indicates a decision in this case?
Yes, I do, Your Honor. The stuff that is in my house, I don't have a PS5 in my house. I left it in the state of Michigan, outside of the front porch, actually, when it was snowing. I did not take that. The reason why there was a statement of saying it was my signature is because the people that Travis was talking to was setting him up. And the items that you would want back of clothing or whatever, I have to go through a lot of things with my stuff, other kids' items, because there is stuff that Ivy still wears because Paisley is passing it down to Ivy of the clothing. So yes, I want other things back. I don't know what other things you would want back. When Ivy wears clothes.
But I've read this file several times, and I could not be more disappointed by the adults in this file. You came to a hearing, and that's what you're here for. So I'm going to tell you, the only truest victims in all this are the children. I don't believe that. I don't believe you can give something to a child and take it back, explaining to the child that you should only get it at a certain time on a certain date. The child doesn't get that. The child doesn't understand that in any way. The child just knows that they don't have it anymore. And if that's the manipulation we're using as adults, then this is really, really sad. So we've come to a really, really sad place here. Okay. The pettiness involved, fighting over stuff when there are genuine children involved. It breaks my heart. It really does. I can't tell you how dismayed I am by this. this is a custody issue in small claims court in district court. This is a custody issue. They can adjourn all the matters they want in custody issues in Arkansas. But I'm ending this today, all right? I'm indicating that today you have not met your burden and preponderance of the evidence. Okay, you have not met your burden. I'm gonna start with a clean slate here. Mr. Winters and Miss Weaver, you do not get any that you're asking of the $6,500 of the receipts and everything, because I don't believe you've proven that this was taken from you. I think half this stuff you'd be taking from children. And I don't find that reasonable in any way, under any circumstances. Ms. Lucero, you do not come out of this empty-handed here. You do not come out of this clean, okay? These children are victims of adults' mismanagement and misbehavior. And there's a sadness to that that's so great. But for this district court purpose, I only have one ruling, and that is that the plaintiff had not proved their case by a preponderance of the evidence in the small claims matter, and therefore the case is dismissed. And that's all I have to say on this. All right. You may follow up with an order if you choose. If you choose not, but the case is dismissed.
Okay.
Go back on the record. SJ Commercial Property versus Thomas Foltz and Irma Foltz. Will the parties please introduce themselves for the record?
Good afternoon, Your Honor. Joy Whitty, attorney on behalf of plaintiff.
All right.
Sorry, Dunlop, on behalf of SJ Commercial Properties, a partnership.
All right. And ma'am, you are Irma Foltz?
Yes, sir. And I wasn't smoking, I was lighting an incense.
Okay, thank you. I just saw the smoke, and I thought better to tell you sooner, because you can always save a cigarette, right? All right. Yeah. This is the time set for a formal hearing in the matter. Miss Whitty, how are we proceeding today?
We met with Irma Foltz through the iPad, and we have a consent judgment with regard to her default as to her husband regarding both the possession and money judgment portions of the judgment.
All right. Did you want to play? Is that a correct statement, Ms. Foltz?
Yes, Your Honor.
All right. So we have a default judgment as to Thomas Foltz, correct?
Correct.
Okay. Default as to Thomas Foltz for failure to appear. And then we have a consent judgment?
Yes.
A consent judgment as to Irma Foltz. And would you like to place any numbers on the record in regards to that? Okay.
The only numbers are with the money judgment. Damages are $8,746.77. Court costs are $266.19. Total money judgment is $9,012.96.
All right. And Ms. Foltz, is that a correct statement of the numbers as you went through it with Miss Whitty?
As she explained it, yes, Your Honor.
All right. Do you have an order for the court to sign today?
If I may approach.
All right. And Ms. Foltz, you've seen the numbers, so you know, you have an understanding of what the court's signing today?
Yeah, the total for what she just described, Your Honor.
All right. So for the record, I will be signing, and those numbers match from what was indicated for the record of today's date, which is January 23rd.
Your Honor, my client is pointing out that we are giving the defendant an extra 4 days to pay. If you look at my judgment form, you'll see that February 2 became February 6.
Yes,
You see that?
February
Okay,
6th,
all right,
yes.
thank you.
So February 6th is been crossed over for February 2nd in regards to that. And I'll state that for the record and I'll initial it. And then I will also sign the default entry as to Thomas Foltz. All right. Anything else for the record in docket 2202-946, Ms. Whitty?
Nothing, thank you.
Ms. Foltz, do you have any questions of me?
No, but I would like to let you know that it's almost impossible to get a hold of any legal aid. I tried to contact them for a month. I did receive contact with them finally on the 14th of January, but yet have not been contacted again. I just wanted to let you know that.
All right. We see them every Wednesday, and I'll pass that on. I know that their resources are low at this point. So, but thank you for that. Anything else for the record in docket 2202-946, Ms. Foltz?
No, Your Honor.
All right, I've got the order. I'm signed it. I'm giving him to my officer, and he'll provide copies. And then we'll move on to your next case, Ms. Whitty. Ms. Foltz, you're free to leave the Zoom courtroom.
All right, thank you, Your Honor. You have a blessed day.
You too. They don't want?
They don't help.
Okay. They should tell her that though. She doesn't know that. She just thinks that they're not calling her back. Yeah, that's exactly right. All right. Miss Quiroga, is she still in the breakout room?
She was with us while we met with her. I don't know what's become.
She's still in the breakout. Let's see if we
Okay.
can move her over. Yeah, we might have to close that. She may not know how to get out of that
I think
breakout.
that's what it is. She was here.
You might have to close that room, Nathaniel.
Thank you.
All right. So there she is. All right. All right, Ms. Quiroga, I'm going to call the case of 2202-947. That is SJ Commercial Property versus Linda Quiroga. Will the parties please introduce themselves for the record?
Joy Whitty on behalf of plaintiff landlord, Your Honor.
And ma'am?
Rita Dunlap on behalf of SJ Commercial Properties Partnership.
All right, thank you. And you are Linda Quiroga?
Linda Quiroga.
Okay, and you can hear me all right, Ms. Quiroga?
Yes, I can, Your Honor.
All right, Ms. Whitty, you had the chance to meet with Ms. Quiroga in a breakout room?
Yes,
Okay.
we met. We did not resolve all issues. I did try to make it plain to her that rent goes up after the complaint, so it was higher than she expected. I did try to explain to her that a landlord will tell a tenant, don't pay me rent, we're in litigation. That seemed to upset her, but I explained that is how that works. They had some complaints about the apartment. And my client basically said if they could pay some rent, I could do those minor repairs.
Okay.
So that's where we are.
So, did you want to start proofs today, or did you want to, does your client want to see if they make those repairs? I guess I'm kind of leaving it because your client knows the status. This is set for formal hearing.
Yes.
We'd have to reset the formal hearing.
I think we should proceed today.
Proceed. I'm gonna do the repairs. I just put a new toilet in. I'm gonna get a new refrigerator.
So we have a second item that's come up, and that is if we're taking testimony, we do have an incidental relationship between my court recorder and so I want to disclose that, okay? So my court recorder is a step niece.
A niece right now.
Yeah, a step niece, all right. And so I don't think that would have any bearing on objectivity in the case, especially my objectivity in the case. It certainly is not required by any blood rule that we would be set parameters, but I want to disclose that, all right? Ms. Quiroga, you understand that? There's a shirt tail relative relationship between my court recorder and the property manager. If you have an objection to it, this is the time to make that objection, and then I'll make a ruling on it.
That's everything as you're saying. That's her
So
niece.
do you have an objection to that, to us proceeding today?
No, Your Honor.
All right. Then, Ms. Whitty, I'll have you call your first witness in regard to this file.
Your Honor, we would call Rita Dunlop.
All right. In the meantime, let's see. You were supposed to meet with Mr. Landon, correct?
Yes.
And so let's put him on the iPad to meet with Mr. Landon.
Your Honor,
Just so we
may I
have
have my
something going
client?
on while we've got proofs going on. So, Mr. Landon, are you still amenable to meet with the tenant in your case now that we
Yes.
have an iPad available?
Can I have my property manager join us, Your Honor?
Sure, and that is
Pandora.
Is that okay? So, Miss Noy, Pandora Noy.
Kanoy, yep.
All right.
Yes.
Let us get that all set up. So, sir, you'll follow my court officer. And then he'll come back and set everybody in the rooms they're supposed to be in. Ma'am, why don't you come up here, state your first name and your last name and spell your last name.
Rita, R-I-T-A, and Dunlop, D-U-N-L-O-P.
Okay, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? Okay, please have a seat right here. Please project for audio purposes. We're recording it. And Miss Whitty, you may proceed.
Thank you, Your Honor. Can you state your business title with regard to the plaintiff?
I'm everything. I'm a handy woman, the manager, the landlord, fix things, pretty much everything.
Thank you. And are you familiar with the books and records for this address, which is 5724 Richwood Street, apartment 103 in Lansing?
Yes, but my partner does the ledger. I can do them, but he does them as well.
Thank you. Did the defendants enter a lease with you for this property?
Yes, they did.
Your Honor, you would have a copy of the lease attached to the complaint.
We do.
And if you would like to have it marked, otherwise we'll simply recognize it.
I think we can just recognize it because pursuant to statute, it has to be made as a part of the complaint. And I do believe we have a copy of the lease. Yes.
Ms. Dunlop, did you file a notice to quit based on non-payment of rent? Did you do that on August 5, 2022? And Your Honor, of course, that's also part of the court's file.
Okay, and that just in regard, that is that it was on August 5th, 2022, and there was service made on that demand for possession and notice to quit.
Thank you, Your Honor. Are the tenants currently in arrears in the amount of $8,060? And do you understand court costs to be $240.19? Are you asking the court for a total possession judgment of $8,300.19?
Yes.
And are you also asking the court for a money judgment?
Yes.
And do you understand that a money judgment currently totals $7,876.77? And
yes.
Is that a yes? Okay,
Yes,
thank you.
I didn't know if it was finished.
That's okay. And with the same court cost, you understand the total money judgment being requested is $8,116.96?
Yes.
And was the property kept fit for the use intended, that of a residential dwelling?
I feel it was.
Thank you, Your Honor. I have no further questions.
Just for the record, what was the court cost again, that number?
Sure, $240.19.
All right.
I have a judgment form at that
All right.
filled out.
Ms. Quiroga, do you have any questions of the property manager at this time?
Yes, I do. We were
All right,
never
so you may.
informed. I'm sorry.
So go ahead. Just make sure it's in the form of a question.
Okay, Rita, can I question her or how do I do this? I've never done this before.
Just the witness. Just the witness.
Okay. I have a question. Why didn't Rita send us a letter saying how much the amount was due now?
So she's asked.
I mailed some ledgers out. I can check my dates. I mailed them out. But the reason why you're confused is rent keeps occurring. Even though the date is August, you're still living there and during this time, and that's why the balance is higher.
Okay. I have another question. Why was it that you kept on, I'm sorry, Your Honor. Why was it that you kept on telling us every time we asked you, do we pay you rent? You would always tell us to get help from programs rather than.
Go ahead, I'm sorry.
Rather than us paying you rent.
When we were involved in the SARA programs, and which sure many have, I asked them and they said for the tenants not to pay the rent during that period, and they were going to advance them another 3 months. So my tenants didn't pay during the SARA programs. Now, the issue we ran into after that is when the date was up, unfortunately, you had exhausted your benefits before their date was up. So then you owed again. But at that point, you didn't offer to pay. I said, try to get help from agencies, from DHS in these places, but nothing occurred. So that may have been the confusion. And now, once I was in litigation, am I correct not to take payment?
Okay. Okay, you were the one that told us not to pay. And you were the one who helped us fill out the forms for the rental and that. And you were the one who dropped off the paper. Am I correct?
You asked me to, the thing with DHS is we can't get any of my tenants out unless they get denied by DHS. They have to fill out the form, and all I do, if they want me to, is I just drop it in the drop box. Or they can mail it in, but the problem is the mailing, takes time. But I do that not just for you, Linda, but others too. If they want me to drop it in the drop box, I do.
Okay, yeah,
And
you were the
told me
one.
got confirmation about it.
Okay, you helped me fill out the form, remember? Because I told you I didn't know how to do all that.
About the SARA form.
Yes.
Was it the SARA? Yes, correct.
Okay, you helped me fill out the form for Sarah and for the DH.
Correct.
And I asked you, because we didn't have a vehicle at the time, if you could drop it off for me. You said, yes, it's no problem. And then we never heard from our caseworker and this and that. And we were trying to get, I would ask Sierra program, what was the, going on with our case and that. And they would tell us that
right, ma'am, you're gonna have the opportunity to make a statement in this case. That sounds like much more, that doesn't sound like a question to me.
Okay, well, I'm sorry. Rita.
So do you have any further questions for the property manager before you make a statement on your own?
Okay, I do have a question for her.
Okay.
Rita, when you called us and told us you were gonna come and fix the rest of the stuff in the house, you said you were gonna come Friday, correct?
That is correct, but I did not make it. I thought I notified you.
No, you did not call us back.
I did fix the toilet. Yes, I put a new one.
Yes, and you told us after you left, you told us you were gonna come back, fix the doors, do the filter, and something with our refrigerator.
And
Ms.
Kroger, what date was that?
It was either Wednesday or Thursday of last week.
So Within the last week, okay.
But it's been an ongoing thing.
But it's been going on rarely with her. We always
Okay.
have to complain about something, and she always tells us, we'll get to it, we'll
Couldn't go
get to
outside
it.
and-
Who's we? She don't have no handyman. That's why we
All right.
always have to wait on things, because she doesn't have nobody to help her.
All right, do you have any further questions before you make a statement, ma'am?
Yes, I want to know if we can do a agreement on payments. Like we were before.
I think that, Ms. Kroga, I think that ship has passed. I think we're already in a hearing, so there are no, this is a contested hearing now, so I don't think we can do agreements anymore.
We were doing that before, and she put a stop to it, because she
Right.
wanted
We're
us
done.
to go to the programs.
Yeah, Ms.
We would
Kroga,
have
there.
everything caught up at the time.
Ms. Kroga, there are no, this is a hearing. Ask her questions. There's no more agreements. Do you have any further questions for the witness?
No.
All right. May this witness be excused?
Certainly. Your Honor.
Without objection, the witness is excused. Ms. Whitty, do you have any further proofs?
I do not.
All right. Ms. Kroga, do you have any proofs today? Would you like to make a statement?
All I want, I mean, we like the place that we're staying at. All we just wanted was our.
Okay, so let me swear you in and you'll say it under oath, ma'am.
Okay.
So the name is Linda Kuroga. It's Linda Quiroga. I'm gonna have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, I do.
All right, go ahead. Now make your statement, ma'am. You're under oath and on the record.
Okay. All we always asked our landlord was to fix things in our home. And there was times that she would work with us and that we were doing payments when she was accusing us of not paying rent. We had all our receipts. This was back when we first moved in here. And excuse me if I get emotion, but I mean, I'm a 54-year-old woman trying to keep a good home for my child, my boyfriend. And it's like she never does anything hardly. She always puts us aside. She does everybody else, but not us. And we get tired of that, you know. We're trying to do good for us. We stay by ourselves. We never get into anybody's business. When our neighbor downstairs in apartment 98 was always harassing us and that, and we would call her and tell her what she did to my daughter and this and that. And we would call the police. The police always said, talk to your landlord. So we did. And Rita would always say, oh, I'm going to do something about it. I'm getting her out of here. Well, the lady is still here and she still harasses us. And she hasn't done nothing. She says, I'm going to put cameras in. Where are the cameras? You know, I mean, we're willing to work with Rita. We've never done her wrong in that. So I don't know why she's treating us so badly when we just looking for a good home to live.
Ms. Quiroga, do you have any other statements for the court?
Yes, I'm diabetic. I have issues, and she knows that. And we live up in this apartment. He's crippled from his legs from accidents and that. We get tired. We can't even walk up the stairs. We've asked her if she can give us a bottom apartment, and she said, and I quote, she said that when we paid the first payment, she would move us downstairs and that. Well, she rented it out to somebody else and never did it for us. She helps everybody else but us. She always puts new carpets in, new appliances. What about us? What is it that you have in for us, Rita? We've done you nothing wrong, and we treated you so nice in that. You say nice things about my grandkids, that you love them in that, and this is how you're gonna treat us? You know, I'm just trying to make a good living for my son, my fiance, and this and that, and you're treating us bad.
All right, so that'll conclude the statement from Ms. Quiroga. Do you have any further proofs today, Ms. Quiroga?
I've written down what all needs to be done.
All right. You didn't appear in person, and I have a live in-person requirement.
Okay, I didn't know.
I
we could
actually
go in
have it
person.
written here, live in-person hearing.
I don't remember seeing that. I'm sorry.
That
Okay.
was set at the last December 14th pretrial, which is why that's why the plaintiffs are here.
There's nothing on this paperwork saying that.
On the last paper that you sent me, Your Honor, it doesn't say in person on that one.
I'm talking about what I actually said in court on the record.
Oh, okay. I'm sorry. I'm sorry. I probably didn't hear. I'm deaf in one ear, so I'm sorry.
All right. Do you have any further proofs today, Ms. Quiroga?
Just what we need, but I mean, just what needs to be done in the home that we reported so many times.
All right. Do you have any further proofs?
No, Your Honor.
All right. Defense rests. Any summation from the plaintiff?
Only, Your Honor, that there seems to be no dispute about the amount of rent that's owed.
Well, from a legal standpoint, this is a real clear-cut case. Okay, the plaintiff have met their burden by a preponderance of the evidence. It is hard for me to take. That's why we have live hearings. It's hard for me to take any exhibits and do a hearing in person by Zoom. But there is a lease here. There is a notice. There's a notice of eviction. There seems to be no debate that there's arrears in rent for at least 5 months. And so all the boxes have been checked. It appears to be habitable. So it appears to be habitable, so habitable that the defendants continue to want to stay there and also continue to want to agree to make payments there. So it tells me the habitability may be a concern, but it's not a legal issue in this matter. Therefore, I believe by a preponderance of the evidence, the plaintiffs have made their case. Their case by preponderance of the evidence. Of evidence. You've stated your numbers for the record. I've written them down. Do you have an order for the court to sign today?
If I may approach.
I will sign an order to that effect. And this has the February 2nd, 2023 date on it. If there's a need for some workaround, I'm sure the landlord would be willing to look at that and make some accommodations. There's a February 2nd date, and I'm signing it today.
It's 10 days.
Your Honor, we've been calling the agencies that are on the court hearing paper, and we got a hold of what, 2 or 3 of them, and we left our phone numbers so that way they can call us back. And we will go to DHS and get a rental information form to fill out.
Okay,
I
ma'am,
did
we're a
mention
little further than that. I've just signed an order of eviction, so that can be enforced on the February 2nd date, February 2nd. Of course, some accommodations can be made in regards to whether the date and time that you can move out, etc. But the ruling of the court is that the landlord has proven their case by preponderance of the evidence based on a lease, based on a notice, and based on the fail to pay and arrears.
But that was not our fault, Your Honor. She was the one who kept on telling us not to pay.
The law doesn't look, ma'am, the law doesn't look at it fault wise. The law just looks at whether the landlord has the money. So, and it appears that there was Sarah involved at some point in time. And after at some point in time, that was not helpful. So anything else, Ms. Whitty, in docket 2202-947?
No, thank you.
All right. Ms. Quiroga, you're free to leave the Zoom courtroom. This hearing is finished. You can provide that to if they want a copy of it.
Like 10 days, you got to kill February 7th.
Mr. Landon, did you have the opportunity to speak with Ms. Williams and Mr. Williams in a breakout room concerning your case?
Your Honor, Juan Casada. I did. And
Okay.
I think we've come to a resolution for entry of a consent judgment.
All right. So we'll be back on the record, docket 2202-926. It appears that Mr. Landon's had the opportunity to speak with the tenants in a breakout room, and there has been a consent judgment that both parties agreed to in the breakout room. Mr. Landon, would you like to put the nature of that in this is as to Lynetta Williams and Michael Williams? Is that correct, sir?
No, Your Honor.
Okay.
The case number was not the same as my case.
All
number.
right, let me see if I've got.
It
Is that
should be real.
Mr. Quesada's case? Go ahead and come up here, Mr. Quesada. Okay, so we're on the record in docket 2202-924. That's City of Lansing versus Juan Quesada.
Rio Town Apartments, Your Honor.
All right, and you are Juan Quesada, is that correct? And Mr. Landon, you've had the opportunity to speak to Mr. Quesada in the breakout room?
Yes, Your Honor.
All right, you may proceed.
Your Honor, possession is no longer at issue because he's already surrendered possession, but we are entering into a consent money judgment today. The damages amount is $2,685.92 with court cost of $212.88 for a total money judgment of $2,898.80.
And that's in regards to the money judgment.
Correct.
All right. And that's those numbers, that's your understanding of the numbers, sir?
Yes.
Okay. And you're going to follow that up with an order, Mr. Landon, concerning the
Yes,
money
Your Honor.
judgment?
I already emailed it in. Mr. Quesada had given me permission to sign on his behalf on those terms.
And Mr. Quesada, everything Mr. Landon said concerning the consent judgment and permission is signed, so the court has it and will sign the order.
Yes.
Okay. Anything else for the record, docket 2202-924, Mr. Landon?
No, Your Honor. Thank you. Have a good day.
All right, Mr. Quesada, you're all set. Okay, thank you.
Thank you, Your Honor. Have a good day.
You too. And it's Miss Kunkel, correct?
Yes, Your Honor.
All right, thank you. As I'm just starting to get my parties straightened out here. So we're on the record in docket 2202-926. That is 1340 South Waverly versus Lynetta Williams and Michael Williams. With a party, and so Miss Kunkel, did you have the opportunity to speak with the Williams in a breakout room?
Yes, Your Honor. We had the opportunity to chat, and it did not sound as though the parties necessarily disputed the rent that was owing. They've indicated that they're in the process of trying to apply for assistance. However, it sounds like they're in need of a judgment in that regard in order to get the potential assistance. So I'm not really sure if the tenants are willing to just agree to a judgment at this time. If they are willing to agree, rather than the 10 days, my client has agreed to go to February 6th rather than February 3rd, I think it was.
All right, so Ms. Williams, I don't know what came out of the breakout room, but this is the time set for a hearing today. And if you need a judgment, we can place some testimony on the record concerning this. it sounds like there's some reason to work in regards to the actual date of possession being turned over. Ms. Williams, how did you want to proceed today? Mr. Williams or Miss Williams?
We're not consenting to that because there was no specific as far as saying yes, we're gonna follow through with this. As far as saying we owe the entire amount and everything else, I had disputes, and the property manager did disagree with me on different areas, even when I brought up other situations. So we want to proceed with the hearing.
All right. Well, this is what we'll do. It's 4:15 right now, and the court closes, of course, at 5. But Ms. Kunkel, I know that you have your property manager here. And
Yes, Your Honor.
yeah, let's go ahead and start testimony in regards to Ms. Schmidt, so we can make a record, and then we can come back and follow it up. But at least we can get some of this on the record, okay, ma'am?
Thank you.
All right. So this is the formal hearing set on the record in 22-02926. And Ms. Kunkel, would you like to call your first witness? You can give a summation or an opening statement in regard to some of these matters, or you can leave it to Ms. Schmidt to explain to the court the nature of the non-payment in this case.
Your Honor, I think it's just as easy if it comes from Ms. Schmidt at this point. This is a non-payment of rent matter.
All right. So, Ms. Schmidt, I'm gonna have you state your name and spell your last name for the record.
Mary Jo Schmid, SCHMID.
All right. You're gonna raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do, Your Honor.
All right. You may proceed, Ms. Kunkel.
Thank you, Your Honor. Ms. Schmid, can you please tell the court what is your business title with regard to the plaintiff?
I am the property manager of Foxland Holdings.
And are you familiar with the books and records of Foxland Holdings?
Yes, I handle all the rent payments.
And Foxland Holdings, is that located at 1340 South Waverly Road?
Correct.
Okay. And did the defendants enter into a lease?
Yes, they did.
And Your Honor, a copy of the lease would have been attached to the complaint if the court would mark that as an exhibit.
I will indicate for the record that the copy of the lease was attached to the original complaint as required by statute, and so the court is in possession. And so we'll indicate for the record that I am in possession of it as a part of the complaint. I'm not going to remove it to mark it just because nobody's here in person.
Thank you, Your Honor.
All right.
And Ms. Schmid, was a demand for possession, non-payment of rent served upon the defendants?
It was.
And was that demand for possession also made a part of the court file when the summons and complaint was attached or filed with the court?
It was.
And are the
All right.
tenants?
So for the record, I do have the demand for possession, non-payment of rent as attached to the file. It was from Foxland Holding. It's in the amount owed of $4,800, and it was certified by service.
And thank you, Your Honor. And are the tenants currently in arrears?
Yes.
And would the sum of $10,800 in arrears in rent, does that sound accurate?
That is accurate.
And have there been court costs incurred in the amount of $130 for a possession and a money judgment, and then service by attachment in the amount of $126.56?
To the best of my knowledge.
Okay. And then Are you asking for a possession judgment today in the amount of $11,056.56?
Yes,
And was the premises kept fit for the use intended?
yes,
And were you made aware that the defendants were withholding any rent due to any maintenance reasons?
I was not.
And so again, you're just asking the court for a possession judgment. Your Honor, I'm sorry, did you indicate that? Your Honor? I think we just lost the judge.
Oh, Lord.
That's not good. Is the court officer still there?
I am going to put myself, what?
I was just gonna say that seems almost impossible since it's his
I know.
event.
I'm going to put myself on mute and attempt to call the court.
Okay. Oh, he's back.
All right, I am back. The Zoom just timed us out. So
Where were we?
So where were we when you stopped, when the court left?
That's a good question, Your Honor. I might just have to recap a couple questions.
Okay.
Miss Schmid, are you asking for a possession judgment in the amount of $11,056.56?
Yes.
And Your Honor, I'm sorry, did you indicate that there was personal service? Or I have attachment?
Service by attachment on the first complaint.
Okay. So Ms. Schmid, you understand that with possession or that with service by attachment that we're not able to ask for a money judgment at this time, is that correct?
Correct.
And so I think that's it as far as the necessary questions, Your Honor.
All right. Mr. and Mrs. Williams, do you have any questions of Ms. Schmidt?
Yes, I do.
Okay, you may proceed.
Ms. Schmidt, is it or is it not true that on December 20th of 2021 that the house that we staying in right now was pink tagged?
I cannot confirm the dates or the year. I am aware that in the past it was pink tag.
Okay, and when it being pink tagged, it was pink tagged by the city, right? Correct?
Correct.
Okay, and with it being pink tagged by the city, is there an expiration date when all the things must be completed? As far as the repairs and everything?
Yes, there is a compliance date with code compliance with the city.
Okay, and do you have any recollection of any of that pink tag ever being, or the city or the code compliance coming out to actually do an inspection? Since
All right. So Mr. Williams and Miss Williams, I can't make out your questioning on cross-examination, and that's not fair to you, and that's not fair to the witness. And the court recorder is really having trouble creating any audio record of this. So my plan is to set this for further hearing at this time and have everybody appear live in person with evidence in hand. Okay, bring your evidence. If you don't bring your evidence, I don't have anything to consider. But I think that's fair to you for your cross-examination questions. It's certainly fair to Ms. Schmidt who I think if I'm having trouble, she's having trouble. And it's certainly fair to Miss Kunkel, who has to answer this in some type of summation and redirect format. So I'm gonna indicate for the record that we started the hearing. And Mary Jo Schmidt was on the stand. The hearing is to be continued live. So let's do this live. That'll take out any of the Zoom problems we might have. So for the record, this is live in person. And we'll get a date for a hearing ASAP.
Okay, but Judge, I have a quick question for you.
Ms. Williams?
Yes, I have a really quick question for you. I just want to know if we are presenting some evidence, or it needs to be in paper form and not on the phone, correct?
That's correct. That's correct. I can't mark it on the phone, but if you bring it for me tangibly, then I can look at it and I can make sure that the opposing party has a chance to look at it also. Okay, ma'am?
Thank you.
Understood.
Okay.
All right.
Thank you very much.
So what date do we have for a hearing date? Probably I'd say about an hour hearing.
February 13th at 2:15.
Okay, so this will be adjourned to February 13th at 2:15. And Ms. Kunkel, since we'll be live, I'll give you the opportunity to go through your case a little bit again on that day, just as a refresher as to why, if you want. All right, ma'am?
Yes, Your Honor. I'm actually looking, I'm trying to figure out, let me see. I am in court at 3:15. I just have to verify with 54A. I'm just not sure which judge it is at the moment.
All right, so you're on February 13th, you need to be here at you're going to be here at 3:15?
Yes, but I'm not sure if it's with Your Honor or if it's with another one of the judges.
It's with Judge.
I'll tell you, we'll set it for that date if you're going to be here already, and we'll figure it out. You can let the judges figure it out, okay?
Okay.
I think, yeah, because I think my hearing that's already started takes precedent over another hearing that hasn't started.
Yes, Your Honor.
But if you tell me what other judge you're in front of, I'll let you know. Miss Schmidt, do you know?
It's with Judge Buchanan.
All right. So I'll talk to Judge Buchanan and let her know that that you're trying to be in two places at once.
Thank you, Your Honor.
All right. Anything, so to the Williams, be here on February 13th at 2:15, all right?
Okay.
Okay, thank you.
All right. So that's all for the record, docket 2202926. We'll see everybody on the 13th.
Okay.
Okay, thank
Your
you.
Honor.
Mr. Mashke, did you have a couple files left that we should look at?
Hopefully just one, that's all I know about.
All right. So I have, is that file 3203? Tayford Kane?
Yes.
All right. So we're on the record in docket 22-03203. That is Kadwa Tayford versus John Kane. Will the parties please introduce themselves for the record again?
Raymond Maskey appearing on behalf of the plaintiff.
And sir, you are John Kane?
Yes, sir.
All right. This is the time set for a formal hearing in this matter. Mr. Mashke, were you and Mr. Kane able to meet or work through any of this?
Yeah, so we actually had, we both executed a stipulated order for a conditional dismissal.
Okay.
And I believe my secretary was successful in faxing it to the court. I don't know if it made it to you yet. But
did you want to put any numbers on the record, sir?
Yeah, I mean, this was a termination of tenancy, but there were several issues back and forth. And I think they've resolved everything, and because of the issues, rent hasn't been paid in a while, so Mr. Kane's agreeing to pay $4,275 plus $166.34 in costs, which includes the February rent coming up.
Okay.
And he's gonna pay that on or before February 28th.
All right.
And if he fails to pay that, then the plaintiff will be able to submit an affidavit of noncompliance and proof of service to the defendant, reopening the case and requesting an immediate writ.
All right. So, do you have a total of the 4,275 and the 166?
Oh, I had it on my notes. So that
I
would
have
be,
$4,441.34.
that is what I have too, Your Honor.
Okay. And Mr. Kane, is that your understanding of the stipend order for conditional dismissal?
Yes.
All right. And Mr. Mashley, did you have Mr. Kane's permission to sign that on his behalf to submit to the court?
You know, he signed it on DocuSign, if that is.
Okay, perfect.
And then
All right.
I signed it, the actual paper, and we faxed it over to the court already.
All right. So the orders to catch up with file. All right. Anything else for the record docket 22-03203, Mr. Mashney?
No, Your Honor.
Anything, Mr. Kane?
No, Your Honor.
Your Honor,
All right,
he did
thank you.
request, he was asking me how he'd get a copy of it. Would the court mail that to him?
Yeah, we'll mail him a copy at the address that we have.
Okay,
So
thank you.
we'll mail a copy to 5831 Richwood, Apartment 5.
Thank you.
All right. All right, that's all for the record in that file. And Mr. Kane, you're free to leave the Zoom courtroom.
All right.
We have one file left. I don't know where Miss Whitty went.
She put her coat on and acted like she was leaving, so.
Are you Bianca Valise?
Yes.
And Cavante Williams? Maybe she forgot she had one last file.
Wasn't she in front of another judge today?
Well, she put her coat on last.
Oh.
Have you had the opportunity to speak to Miss Whitty or anybody representative from D&K Rentals? We wouldn't have time to do a hearing anyway today, because I mean, there's just no time to do a hearing.
She's in front of Judge Buchanan right now.
Is she?
She has she had a 3:30 in front of Judge Buchanan. I don't know if she's still in the building.
Okay. Regardless, it's 4:35. I don't see us having a real hearing in this matter. Let's reset it. Let's reset it for hearing.
Can I ask you a question?
Sure.
Even, I'm just their grandmother. All this is about is that she just has to show proof that she has got comfort animals through, what is it?
American Service Pets.
And what's the other place? The
I'm
Civil
in
Liberties
contact
Union.
with someone from the Department of Civil Rights about this.
And you probably should talk to somebody, to the lawyer on the other side. And she was here. She had hearings here. And now she's either in front of another judge. But regardless, you should talk to her, because if you have paperwork she should see, then we may not need a hearing today. But in order just to make sure, let's reset it, because we couldn't have a hearing today anyway. It's 4:35. So, and I have to make sure, union rules say I have to make sure my staff gets done by 5, or at least around 5, right? You know?
Where you don't run out of time.
Yeah, or Zoom tells me that it's all over anyway.
Yeah.
So I'm going to indicate that the defendants were here in person.
When you mean talk to the other side, do you mean talk to?
I would talk to the Whitty law firm at this point. Okay.
Oh.
I would talk to one of the Whitty law firms who are representing him in this matter, and that might be the impetus to resolve the case in the way it needs to be resolved. If I had known,
Send Woody the letter.
yeah, if I had known that she needed to talk to you, we would have got it done. But I didn't know that this far down, and I didn't know we were going to be this late. Okay.
It's been interesting today, and you're quite comical, actually.
Yeah, well, I'm glad somebody thinks so.
Some of the grins were kind of hidden hard.
So the defense were here in person. Plaintiff was here for hearings. I'm going to indicate we ran out of time. At 4:35. And how about a new date for hearing? And that'll be live, so make sure you come in person, and let's put it at the top so I don't.
February 13th at 2, please.
February 13th at 2 o'clock.
Can you get up? Can you get up for that? Okay.
That'll guarantee that we get to see you, because the further you fall down, we start running out of time. Okay.
We were here.
Yep. I saw you here. I know.
I went in the wrong courthouse at first and went to the second floor and went, uh-oh.
Well, maybe you were lucky it was 3 o'clock then. But so now you know you're supposed to be back here at this courtroom on the day before Valentine's Day, February 13th at 2. In the meantime, if you get to talk to Miss Whitty, maybe you can resolve this, okay?
Okay.
All right.
Okay.
Mr. Neves will have your notice, and you should be all set today.
Okay.
Thank you for your appearance
so
today.
much. You have a good evening.
You too.
You also.
Thank you.
I do not like the new one.